Your Lakshmi asked the judgment in that model for Mishra versus about no time limit was fixed in that case for the implementation of the judgment. And High Court register, High Court has referred two reviews against that orders. They are not being listed in spite of our best effort. We have already entered appearance in the space. I pray that any day convenient to your Lordship takes up that review matter so that we are not kept hanging for all times to come, jeopardizing our service career.
Already give the memos.
Yes, but I give my
Well, for the Honorable Chief Justice, that would be better. Because this bench is constituted. It's all right, the obstruction.
Can we tell that we mentioned before your Lordship?
Yes.
Maybe talking to mention, the matter not in your Lordship's court. Lordships have fixed the date of 16th June. I have already deposited a substantial amount of money. These are writ applications against orders of the DR81. The matter was fixed to 16th June. It hasn't come up. We have filed. I'll keep up memo. Publish.
My lord, petitioner is in custody.
The ex parte interim order is operating since March 24 against the bank. The entire suppression proceeding is stayed. I filed the counter also, filed an IA to vacate the interim stay. It is not coming.
My lord, pension matter. Pension matter.
JCL matter.
My lord, petitioner is in custody since 16 years.
One JCRL matter, petitioner is custody more than 6 years.
You forgot to mention item 30. It is in your office today. Can be taken up after 12. We have taken possession. So then access that possession. So we are unable to. We are going serially. If you want. I have for the state committee. You want adjournment? No. Then maybe taken up. We are going serially. Why are you making mention? It is not reaching that way. No. See that. 29 to 30.
Item 8 million. I have some personal inconvenience today. Can it be taken up day after tomorrow? 8. I will inform the officer.
So Brahm Subhushan Mahanti is in the other side.
Inform for they be point out which back like suddenly I got today only I have difficulty. Day after tomorrow it can be taken.
We are just noting it down.
Thank you.
Item 18 units. Have taken consent from the Nurse Senior. 10 days time to take sentenced. And for the opposite party number 2.
I am for the other side.
Which for the petitioner?
I'm for the petitioner. Counter yet to be filed.
Item number 18.
18.
The Land Counsel for the petitioner is present. The Land Counsel for the opposite party number to seek some time to file counter affidavit.
Not counter, take instruction.
To take instruction and to file counter affidavit if any question. Land Counsel for the petitioner has no objection to such prayer for adjournment. Release this matter. 2 weeks for us.
Interim not to continue.
Interim order to continue.
Item number 3.
He has no objection, Major.
We are not, we'll just take up and see that. Yes.
This is a order of that under challenge. And the subject matter of challenge is that petitioner was transferred from JNB Khorda to JNB Mayurvanj. This honorable court directed to obtain an instruction that whether there is any vacancy in the nearby JNBs. We obtained the instruction, we filed an affidavit since 16/7/2024. Right now, like petitioner has
Give the memo.
Some counsel is appearing for opposite party, so let them appear. One is Saroj Kumar Das and B. Kadari.
What is this matter 2019? You are seeking for adjournment, no?
Only whether the file has been misplaced. For that reason, I am actually thinking.
The
Next week,
order was passed on 14/5/2022 when a submission was made by the Gramya Bank that the outstanding dues against you in the year 2019 was 7 lakh. And on negotiation, it was settled that you are to pay rupees 5,50,000
Yes.
under the OTS, but you did not pay single pie thereafter.
I'm ready to, sir. I'm ready to make the payment. That observation can be disposed of. I'm ready to make the payment.
No, now it must have gone off because this order was passed in the year 2022.
Sir.
So
for 19 onwards, you have been getting seeking adjournment in this matter.
Last, I think last.
No, just see 14/12/2019 adjournment. None appear for the petitioner.
Sir, I may request.
I'll just read 1 minute.
Today, or it may taken up to
1 minute. Next, 8/2/2020, the observation is for the non-cooperation of the side of the petitioner, freeze the matter. And thereafter, you just see next order is again 2022. Since no one appears on behalf of the petitioner,
sir, I am extremely sorry. It must only
1 minute.
last, sir,
1 minute.
Last chance.
1 minute. Let
Sir,
us complete.
sir.
Next, again on 2024, again you sought the time.
Sir.
Thereafter, again.
It can be disposed of today or may add them 2 weeks after. I don't have any objection. If my lord said that can't be disposed of.
Open for him.
This writ petition has been filed by the petitioner, Shangram Kesari Mishra, with a direction to the opposite party to furnish all the documents sought for to the petitioner with a further direction for one-time settlement of the loan account of the petitioner. The matter has already suffered 8 adjournments. When the matter was restayed on 14/5/2022, the Running Counsel for the Orissa Gramya Bank made a submission that in the year 2019, the outstanding dues against the petitioner was rupees 7 lakh. And on the
that item, outstanding 9,29,000 but they are settled on 50,50,000. 14/5/2022
the whatever order is been written, we have-
14/5/2022
there was an outstanding dues of rupees 7 lakhs in the year 2019 against the petitioner, and on negotiation it was settled that the petitioner shall pay sum of rupees 5,50,000 under the OTS, but the petitioner did not pay a single pi thereafter. And as on 14/5/2022, the outstanding dues was 9,29,280. Stop. On that day, nobody appeared for the petitioner, and the matter has also been listed in the National CORAM on 17/3/2024. And since nobody appeared for the petitioner, on the submission of learned counsel for the opposite party's bank, the matter was directed to be placed before the regular bench. The learned counsel for the petitioner submits that he has received instruction that the petitioner is ready and willing to settle the loan account. However, after the order dated 14/5/2022 of this court, no amount has been deposited with the bank. In view of such state of affair, we are not inclined to accept the prayer made in the writ petition. It is open to the petitioner to approach the bank for negotiation and amicable settlement of the loan account. Accordingly, the writ petition is disposed of.
All right.
And for opinion.
The Mr. Arvind Mahathir and counsel for the opposite party present. Yes.
Item 2.
Item 2, there will be a loss in the take up after 2 weeks. Because in the meantime, the development is there that annexure opposite party number 5 and the bank, they have on negotiation, the OP number 5 has already, OP number 5 has already deposited certain amount towards the loan. Here, my lord, I have challenged the order of attachment issued in a recovery proceeding by the DRT. My lord, I am the owner of the property.
You are agreed by which order?
No, at the order of attachment, annexure 3, your lords will get.
You are the guarantor.
No,
Then
I am the purchaser of the land.
subsequent.
So subsequently, that land was mortgaged by the my vendee as guarantor. If initially it was mortgaged before the Andhra Bank. Thereafter, it was released. I purchased the land. He took money from me, paid to the bank released the same. Suddenly it was executed in my favor. Subsequently, my vendee, when OP number 6 availed a loan from Bank of Baroda, he mortgaged that property without my knowledge. Now, my lord, a proceeding was initiated before the TRT. And
No, it's all right. But this notice which you are referring to, that is under annexure 3. That is dated 9/1/2025.
Yes, sir.
And you are a party to that proceeding.
No, no, sir.
Then
I am not a party, sir.
why are you not filing an application to recall that order? If the order is against you,
It is
and-
not against that person, but the land is sale. Now, my lord, to my instruction, the OP number 5 has already paid some substantial amount towards that loan.
There is more of a reason that you should move an application now.
move an appropriate order.
Who give that liberty?
You are challenging the notice of attachment of the immovable property, for which you have made the payment.
Yes, I have
So-
made the payment, I purchased the
So
land.
you purchased the land,
Yes.
so all the documents must be in your favor.
That annexure one.
So it may be so that all these things might not have been brought to the notice of the
Yes,
debt
because
recovery.
I was not a party, so it
So
was.
that is why you can file an application for intervention and bring all these matters to the notice of the court.
Liberty.
Look on, this writ petition has been filed by the petitioner Rajendra Lenka with a prayer for quashing the attachment notice under Annexure 3, which was issued on the basis of an order passed by the Debt Recovery Tribunal in RP number 12/2018/CTC dated 9/1/2025. And with a further direction to prevent the opposite parties number 2 and 3, that is the authorized officer, Bank of Baroda, and branch manager, Bank of Baroda, from attaching and taking possession of the properties of the petitioner. Which is the landed property appertaining to plot number 709, acre 0.007 decimal under khata number 85 of village Vidanasi, bracket unit 3, Cuttack town. The land counsel for the petitioner submits that on the basis of the sale
On the basis of
on the basis of a registered sale deed number 6742 dated 26/9/2018. The petitioner not only paid the consideration amount, but also the possession of the land was delivered to the petitioner. And he is purchasing the land and residing over the said land and building with family. The land counsel submits that the petitioner has not been arrayed as a party in RP number 12/2018/CTC in the DRT, and the order has been passed against him, which is not sustainable in the eye of law. After taking into account the submission made by the land counsel for the respective party, for the petitioner, the documents filed with the writ petition, we dispose of the writ petition, giving liberty to the petitioner to approach the Debt Recovery Tribunal, Cuttack, by filing appropriate application, putting forth all his grievances, and which can be considered in accordance with law. Accordingly, the writ petition is disposed of. Yes.
Petition number 5 is your brother only.
No, my lord.
Cousin brother. Cousin brother.
Yes,
Not-
next.
No, it's not.
Item 3.
Nadi only two brothers.
My lord, item 3, my lord. I pray for time, my lord. The coordinate bench.
So also in the OA, your lordship may say, because in the OA, he was also notified. RP and the original application,
Which one?
that annex of item 2, ma'am.
It's all right. We are giving you liberty. Go on. Yes, next, item 3.
My lord, I pray for time, my lord. Coordinate bench of this honorable could direct me for regarding maintainability of the writ petition. I have not do so, my lord.
We are already.
Sir, मुझे कही दे.
No,
Twice you have already taken.
just a minute.
First time, my lord, your lordship may see the order. Last occasion, lordship had the matter, then directed me to prove the maintainability. This is the first time, my lord.
What do you want now?
But pray for time, my lord. I have not verified the maintainability of this writ petition.
You are for the bank.
Actually, he has filed a petition challenging the order of the DRA. So DRT has dismissed the essay which has been allowed by DR. And now in this petition, what he has challenged that this court shall give the repossession of the property by dismissing
The DRT order has been confirmed by the DRT.
No, that's been set aside.
Oh, set
Set
aside.
aside. So that is against that he has come.
Okay.
So in 227, neither all the points he has taken, whether it is maintainable. But in the prayer, he has stated that this Honorable High Court may hand over the repossession of the property which has already been taken by the bank under 13(4) and then,
All right.
then say dismissal.
Let him get prepared for it.
So a short time may be given.
And counsel for the petitioner. Seek some more time to argue regarding where this question of maintainability was raised.
Raised in 17/4/2025, the last package, last
order.
Last one.
17/4.
2025, and he has taken a long time.
There is no order on 17/4. There is an order I passed on 1/5. Acha. 5/4 with the first order.
1/5. 1/5/25.
Then 1/5/25. Also adjournment to with regard to Mentacha. Regarding maintainability as well as the merit of the writ petition, as was observed in the order dated 1/5/2025. Put of this matters and the Land Counsel for the State Bank of India, Mr. Mahapatra is present. No, that is just first 2 weeks.
Date when fixed, so that.
You'll find the date in the evening, okay, in the High Court website. Yes.
Item 4.
Lord, in this case, filed an IA for amendment of the Quashing manner. That is 10,890. So I would have sought the copy in the Union of India manner.
Any objection? Just formally that post title is to be amended.
The opposite party number 1, my lord, name.
Opposite party, देखिए ना नहीं?
No, my lord, he has served in the DSA office. I have not received the copy. And at the petition, my lord, here he has amended, he wants to amend the opposite part number 1, that is Secretary Steel and Mines, to, my lord, the Managing Director of Raulkela Steel Plant. My lord, once Raulkela Steel Plant is made party, we cannot enter offense, my lord.
No, the schedule of amendment is Union of India represented through Secretary, Minister of Steel, Government of India, Udyog Bhavan, New Delhi. That's all. Are you entering the appearance for this? So then,
he wants to amend that, my lord.
Yes.
schedule of amendment रे एई जिनसटा को आनिया चाहुचंदी ए पई आपण appear करिवे तो he has sought the copy in your office, so it is up to your office to provide you.
Amendment may be allowed.
So here कोना unnecessary सम्मान देखो IN number so and so. This is an application for amendment of the post title of the writ petition, particularly the name of the opposite party, number one. The Land Council for the Union of India has no objection to such prayer for amendment. Accordingly, the prayer made in this interim application is allowed. The Land Council for the petitioner. Achi, ready achi, first title da.
The problem is just see the Annex 8. Come to the impugn order. See, Union of India, here also you have done the same thing.
Yes.
Now, if you want Secretary to be a party, Secretary was not, Union of India Steel and Mines, Secretary was not a party before DRT. In the writ petition, we want to including. That's the problem.
Yes, my lord, I have read it as per the.
That is, the wrong has been committed there in the tribunal.
Yes.
Because if you we allow the application, then the secretary will be a party.
Yes.
Who was not a party there. Tomorrow he will make an objection that in the tribunal I was not a party. That's the whole difficulty.
The Union of India has not any role at all in this case.
That's right, but
Then they say amendment is not necessary.
Union of India has no objection. Accordingly, the council is made a party. The Land Council, the petitioner, is permitted to file the press cost title of the petition incorporating the newly named opposite party number one. You file it that cost title, okay? Consolidated cost title you have filed?
Yes, my lord.
The consolidated cost title has been received, so and so that is same is accepted. You have given a copy to the Land Council for the Union of
Yes,
India.
already has been.
The same has also been given to so and so. Yes, what do you now want?
Challenging the order passed by the Central Administrative Tribunal, my lord.
Yes.
My lord, here petitioner is the son of the deceased employee, my lord, who was served under Rourkela Steel Plant as a senior technician. My lord, after working for 35 years, he was while he was leaving office due to illness with permission of the authority, on the way he faced an accident. And after that accident, he was shifted to the IGH hospital. Then, my lord, after sitting there for 5 days, he was died. Then, my lord, the wife of the deceased has filed a representation before the authority for considering his son for the appointment under rehabilitation assistance, and that has been rejected. Challenging that, my lord, he has filed a writ application before this honorable court, and that has been shifted to the Central Administrative Tribunal on the ground that it is not maintainable here, so it may be adjudicated there. Then, my lord, that has been allowed. Kindly have a glance, my lord, Annexure 6, page 22, my lord. The operating part is, my lord, at page 27. May I please? In the circumstances as directed above, the following judgment of Honorable High Court in case of Gemma Supra cited by the applicant counsel, we hold that
The death of the applicant number one husband was death out of and in course of employment and unable to accept the contention of the respondent in the case. Thus, the answer to the question in paragraph 8 of this order has to be in affirmative, and applicant number 2 will be entitled for being considered for compassionate appointment in terms of circular dated 1/1/1996. Accordingly, the impugned order at annexure 4 and 6 rejecting his prayer for set aside the matter is remitted to the respondent to consider the case of the applicant number 2 for compassionate appointment in accordance with the scheme for compassionate appointment and pass an appropriate speaking order to communicate the decision taken in this regard to so manner.
Yes.
This order has been challenged by the respondent and by WPC number 21732 of 2022. That is at annexure 7. And an operating part is at page 29. Having heard learned counsel for the parties, it is evident that the matter was heard and reserved by the tribunal on dated 16/3/2020 and the order was passed on 13/5/2020. My lord, after 21 days the order was passed. The Honorable High Court has directed to hear the matter and pass appropriate order. And then it has been again transferred to Central Administrative Tribunal. Then my lord, final order was passed at annexure 8. And here the operating part is my lord at page 40 my lord.
40?
40 my lord.
Para 9.
Para 9. In the instance case, father of the applicant number 2 on 27/1/2023 left workplace for medical checkup and met with an accident en route and admitted in IGH Hospital Rourkela, where dated 5/2/2023 breathed his last. Admittedly, the accident took place on the 5/2/2023 outside the office premises for employment and for the decision of the Honorable Apex Court in the case of Regional Director ESIC Corporation and Anand Augustus Francis Krishna. And it has been rejected. Your matter once it has been allowed in the ground of that.
This finding is contrary to the finding given earlier.
Exactly, ma'am.
And the remittance by this court is limited on technical ground. Finding is not upset.
That
This petition has been filed by the petitioner Sheikh Abdul Ali, challenging the judgment and order dated 3/3/2025 passed by the Land and Central Administrative Tribunal in TA number 260/0012 of 2014. In dismissing the original application. The learned counsel for the petitioner submits that at the first instance, the petitioner, along with his mother, approached the Land and Central Administrative Tribunal in TA number 12 of 2014. With a prayer for a direction to the Steel Authority of India, represented through the Managing Director, Rourkela Steel Plant, to provide employment to the petitioner on compassionate ground as the father of the petitioner, who was working as a technician under the unit of Steel Authority India. Died while attending the duty and returning home by meeting a road accident. The London Central Administrative Tribunal, by order dated 13/5/2020, allowed the original application and directed the opposite parties to reconsider the case of the petitioner for compassionate appointment in accordance with the scheme and to pass a speaking order in that regard. Stop. The Land Council further submits that the aforesaid order passed by the London Central Administrative Tribunal was challenged by the opposite parties before this court in WPC number 213732 of 2020. And this court by order dated 27/1/2023. Taking into account that there is violation of Rule 105 of Chapter 17 of the Central Administrative Tribunal Rules of Procedure 1993. As the order was passed beyond the prescribed period of 21 days, na?
Yes, sir.
21 days, was the order of the London Tribunal and remitted the matter back to the Central Administrative Tribunal for re-adjudication. And after re-adjudication by order dated 3/3/25 under Annexure 8, the London Central Administrative Tribunal took a completely different view than what has been taken earlier under Annexure 6, which is not sustainable in the eye of law. Stop. Issue notice on the question of admission indicating therein that the matter shall be adjudicated, disposed of at the stage of admission. Land Council for the Union of India accepts notice on behalf of all the opposite parties.
Only opposite partner one. 2 and 3 notice to go.
Steel Authority पे अपन ना Union of India opposite party number 1. Steel Authority of India के panel council अच्छी ना ना notice जो.
Mr. M.K. Sahoo Hon'Ble was appearing there before the law court below. Nirod Kumar Sahoo.
अच्छा लेकिन
Notice में भी
requisites for issuance of notice on opposite parties number 2 and 3 be filed within a week. This matter took 4 weeks. Date they given. Counter affidavit, if any, we filed in the meantime. Yes, next.
Item 5.
Transaction against the London Magistrate to dispose of
Section 14.
was based on the pending since 1st October 20.
Number के ते case रो. Number टा कितने अपन को जो 14 रो.
Magistrate don't know.
कहीं लोग ना.
Indian side, but
CGM तो दो CGM तो अब तंग रो case registered ही होती हो. से ठीक कौन case तो registered होती हो ना वो case number पूर्ण होती हो.
Number of the case should have been allotted.
बर्तमान whole difficulty कौन होची माने अपन number न देला तो आपण को case file करचंती केबे file करचंती को दिन registered हेची all these things status आनिबे ना हम that is the difficulty.
below they put the seal, the collector, 1st October 24, they received it.
First October.
First, the page 10,
2024.
towards end, left hand side towards end.
Why are you not asking them to provide the number of your case? They have, if they have accepted and it is to be registered as a miscase and you filed it in 2024 and according to you, you are not aware about the number of the miscase, why are you not filing at least some application that under the RTI to know the status of the case or to provide the number at least?
Now, imagine a situation, you went and gave it in the dispatch section. The time frame prescribed under the 60 days will be from the date of registration, when it will be registered. If it is registered after some time, the time has to start from that date of registration. It is not even registered. It looks like.
Because the date of filing, if your the date has been mentioned in your petition, that 14 SARFAESI petition, it is 110 or 710/24. 110/24.
Page 10.
Counter filing also countering the filing
ଦେଖନ୍ତୁ ଆପଣ ନମ୍ବର କ'ଣ ପାଇଁ ଦଉନାହାନ୍ତି? ଆପଣ ଯଦି ଏଇଟା କଲେକ୍ଟରେଟରେ ଆକ୍ସେପ୍ଟ କରୁଛନ୍ତି, there must be a section who is accepting such type of application. So you should provide a number immediately.
What is the practice? File kala par number mile.
Section 14 ର application receive କରିବା ଗୋଟେ section ଥିବ ନା, right? ତ ସେଠି ଆପଣ ରଖିଦେଲେ ଫିଲ୍ଡ ମାରି ରଖିଦେଲେ ବାସ୍, ସିଏ ତାଙ୍କୁ ନମ୍ବର ଦେବେ ବା କେବେ ଟେକ୍ ଅଫ୍ ହବ କ'ଣ ହବ ତାଙ୍କୁ ତା କିଛି ଜଣେଇବେନି, because the duty is cast on to dispose of the petition, as my esteemed brother has pointed out, that is 60 days.
60 days, that is all.
So, and 60 days from the date of, so obviously, if you will not give any date, then you may likely to dispute that I have not received the application on. We just ask you to bring it to the notice of all the collectors that whenever such an application is filed under section 14, number should be immediately given to the concerned party. Hello?
It will be registered and the number should be allotted.
No. This writ petition has been filed by the petitioner Tata Capital Housing Finance Limited for a direction for early disposal of petition filed under section 14 of the SARFAESI Act by the District Magistrate Puri. The application has been annexed to the writ petition as annexure P/1, from which it appears that it was filed on 1/10/2024. However, the number of the miscase is not there in the first phase of the application or petition. When we asked the Land Counsel for the petitioner regarding the number of the miscase, he submitted that the number is never provided by the District Magistrate Puri. Let the Land Counsel for the state not only obtain instruction about the status of miscase which was stated to have been filed by the petitioner on 1/10/2024 before the District Magistrate Puri, but also obtain specific instruction as to why the registration number has not been provided to the petitioner. as the provision under section 14 of the SARFAESI requires that the said petition is to be disposed of within 16 days. এটা কোন প্রভিশনটা ନାଇଁ ତାର 14 ର କେତେ ସବସେକ୍ସନଟା କେତେ Five. Provider 1 na 14 ର
The second proviso was last provided further the receipt of.
এটা second provider আচ্ছা section এটা করে দিন 14 bracket রে 1 bracket রে IX second proviso to 14 bracket রে 1 bracket রে IX হলো next time যেটা আসে ওই দেখি it has invariably come to the knowledge of, to the notice of the court that the numbers are not being furnished to the persons who are filing such type of petition. The Land Council for the state shall specifically instruct, for example, that in this respect to the let all these ones so they let all the district magistrate Puri register the case,
register and allot numbers.
Check the case, register the case on the date of filing of the such petitions
And
assign same to the and inform the party in that respect. Yeah. This matter will taking on today is 7, so let it come on 21st July 2025.
Item 6.
The petitioner booked one flat and the opposite party number 1 and 2. Since the construction of the work was not completed, we approached the RERA authorities. RERA authorities allowed the complaint case. Thereafter, the opposite party number 1 and 2, they filed appeal. In the meantime, the financer issued annexure 1, my lord, at page 9. Sale notice, auction sale notice, which was ordered notice dated 17/6/2025. The mandatory provision 1 month has not been given to the petitioner and date was fixed on 2nd of July.
No, e-action cell notice ପୂର୍ବରୁ ସେଗୁଡାକ ସବୁ ହୁଏ
Sir, ସେଗୁଡ଼ା ସବୁ କିଛି ପାଇନାହାନ୍ତି. They have not received any 13/2, 13/4.
No, 13/3 ରେ ଆପଣ objection ଦେବେ
13/2, 34 ଆମେ ପାଇଲୁ ଆଜ୍ଞା। ଏଇଟା ହିଁ ପାଇଛୁ।
how can it be?
ତାପରେ ଯଦି
Because
ପାଇଲ
this,
ପବ୍ଲିକ ନ୍ୟୁଜପେପରରେ ପବ୍ଲିଶ ବି କରିଥିବେ। That is also the petitioner has no knowledge.
Because we cannot entertain the writ petition on this challenging this cell notice in view of the
But notice to the bank by the
No.
financer.
Where have you stated that prior to issuance of this sale notice under annexure 1, no communication has been received?
Para
from
6.
the-
Para 6. We have mentioned that the petitioner humbly submits that the auction of the LIC Housing Finance Limited opposite party number 3 in putting the property under auction is bad in law and This is in contravention to the SARFAESI Act. Further 1 month personal notice has not been served on the petitioner before putting for e-auction of the property. In addition to the above, neither notice under section 13.2 or 13.4 of the SARFAESI Act has been served on the petitioner before issuing aforesaid notice for sale.
And the date of sale is already over.
My lord.
So it may be so that third party right might have been created in the meantime.
No, auction is failed.
No. Then bring it to all this, what happened, because the date is very clear on the auction sale notice. So who is the bank or the housing? You can bring it all to the notice of the DRT. There is no problem, since the auction, you say that it has failed. So you have got sufficient time. So they may issue phrase notice also. And in the meantime, you bring all these things so that it can be better adjudicated by the the petitioner. Birusumati so-and-so has filed this writ petition challenging the sale notice dated 17/6/2025 issued by the opposite party number 3. An averment has been taken in the writ petition that the action of the opposite party number 3 in putting the property under auction is bad in law, as there is contravention of the provision of the SARFAESI Act, and 1 month notice has not been served on the petitioner before putting the property to e-auction, and neither notice under section 13.2 nor 13.4 of the SARFAESI Act has been served on the petitioner before issuance of such sale notice. However, when we found that the date of sale was mentioned in the sale notice to be on 2/7/2025, we made a query to the land council for the petitioner as to what happened on that day. The land council for the petitioner submitted that the auction sale has become unsuccessful. Since after going through the pleadings, since we find that the petitioner has got an alternative remedy in the DRT to raise all the issues, this petition is disposed of, giving liberty to the petitioner.
Without the notice.
Raise all those points. Yes.
How can we do it, my lord?
Raise all those points. It can be adjudicated.
Without those notices, that is not maintainable.
We do not know whether notice, that is your averment, and once it is filed, they may produce that notice and all these things before there. Yes. Next.
Item 7.
Yes, item number 7.
Please. Now, in this petition, challenge the order passed by the Judicial Magistrate who rejected my application on section 14 of the SARFAESI Act. Getting into the merits of the case and decided.
No, against 14, you have the alternative remedy.
No, I do not have it.
No.
Secured creditor doesn't have it. It is the alternate remedy 17 is available to the borrower or any other.
No, against the order passed under section 14, you have got no alternative remedy.
17 you can
If
file.
it is Magistrate, if it is allowed, the alternate remedy is 17. If it is rejected, then the writ petition. But this honorable court has decided. Yes. The coordinate bench.
Which judgment?
Show us the thing.
Mr. Panigale, in this case, number was allotted, 13.
Chief Judicial Magistrate,
Chief Judicial
Chief Judicial Magistrate.
Semanakot.
Semanakot, please.
The coordinate bench of this honorable court, the philosophy is.
There was a line article, though, the judicial magistrate.
How this practice, but which paragraph?
Page 77, paragraph 28. 28 is page 76, page 77 is Lordship may come. The conclusion part, Roman 4, 1b. Page 77 is Lordship. Place it.
Roman 4.
Yes, sir. That's the concluding part.
If in case.
In case if the district magistrate fails to pass an order in terms what is provided under section 14 of the Act 2002, or if the same is not being implemented, the secured creditor would have the remedy of invoking the jurisdiction of this court under Article 226 of the Constitution. Because with the language of section 14 of the SARFAESI of the law, it says that 17 of the SARFAESI, I'm sorry, it says if the measures taken under 13.4, then the remedy is available for the borrower. Motion of analysis, section 17 for you.
Yes.
The application against the measures to recover security. Any person, including borrower, agreed by any of the measures referred to in subsection 4 of section 13 taken by the secured creditor or his authorized officer under this chapter may make an application along with such fees as may prescribed to the Debt Recovery Tribunal having jurisdiction in the matter within 45 days from the date on which the measures have been taken. So dismissal of the application is not measures taken, measures not taken. That is why this honorable court has interpreted that and held if it is rejected, then the option is remedies before this honorable court under 226. If it is allowed, then the measures taken. Then the parties are they are having the remedies under 17. But in this case also the Tribunal Magistrate had rejected the application. So that was under challenge. And this honorable court held that the date is maintainable.
You are not the creditor.
I'm the
Creditor. Who is
I'm the creditor.
you are creditor?
Petition is the bank.
Okay, bank. Okay. Okay. Acha, you.
What order was passed by the,
Madam,
you are agreed?
Madam. That is it, page 19. Of the restriction.
Yes.
It starts from 14. The operating part is 19 by calculation. Heard the counsel for the secured creditor, while papers available in behalf, it appears that the petition was filed by the secured creditor before the collector cum district magistrate Cuttack in section 14 of the SARFAESI Act. On 21/2/2024, the collector cum district magistrate rejected the petition on the ground that the Honorable NCLT Cuttack bench in CPIB number has initiated proper resolution process after the borrower's organization was declared insolvent and bankrupt. The Honorable NCLT Cuttack bench has made public announcement as per section 15 of the Insolvency and Bankruptcy Code 2016, inviting operational creditors and financial creditors to submit their claim before the IRB, Mr. Sonsu. The collector cum district magistrate Cuttack in his order has observed that section 14 Insolvency Bankruptcy Code prohibits an action in the SARFAESI Act for which he rejected the petition on the ground that it was not entertainable. Thus, the petition filed by the secured creditor before the collector and district magistrate was disposed on merits. A similar petition on similar ground is not entertainable and therefore petition is rejected. Now, there are two issues arise.
Then why don't you go to NCLT then?
NCLT doesn't have any power. That is what the correction was, if I can submit. Section 14 of the IBC, there are two issues involved in this petition I have raised. One is the scope of the London magistrate while adjudicating Section 14 under the SARFAESI application. The Honorable Supreme Court in so many judgments has held that it is not an adjudicating process. It is simply a ministerial job. At the time of adjudicating, it is not an adjudicating process. At the time of entertaining Section 14, the magistrate ought to have seen only the application and the affidavit filed by the secured creditor, not beyond that. He is not competent to adjudicate any issues.
So what will happen to the resolution proposal if it comes?
Now, Lordship may kindly see Section 14 of the IBC.
Right.
The background of this case is this property which is under SARFAESI belongs to a guarantor.
Who has resorted to IBC proceeding?
IBC proceeding by the one of the borrower.
Financial creditor.
Yes. So one of the borrowers is a company, but the property doesn't belong to the company. So the Section 14 moratorium which we talk about, that precisely confines to only to the corporate debtor. And there is a judgment also on site.
But once the 14 is allowed, and it can threaten the proceeding of NCLT.
No, that is not 14 IBC confines to corporate debtor only. This property belongs to the guarantor. That's why in IBC also the Section 60 was incorporated to the amendment and it was notified later on, which pertains to the guarantor's property and the insolvency against the guarantor. So 7, 9 and 10 of IBC speaks about the insolvency proceeding of a corporate debtor. 7 is the financial creditor, then the operational creditor, then the Section 10, the company goes for insolvency. For the guarantor, Section 60 starts. If that's why in a judgment, the Honorable Supreme Court say that it doesn't have an application to the guarantor's property. So let's see Section 14 of the IBC.
Drawn out. All other proceeding comes to this. Where is that provision, IBC provision? It says that once the IBC is invoked, Section 7 is invoked, all other proceeding like SICA Act, Section 22, parametria with that.
Section 7, 9 or 10, any of the three proceedings admitted,
including 14.
Section 14 comes into effect. Section 14 is the moratorium.
So was that provision.
See Section 14 of the IBC. May I place it?
Yes.
Subject to provisions of subsection 2 and 3 on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all the following, namely the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority, transferring, encumbering, alienating or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. Any action to foreclose, recover or enforce any security interest created by the corporate debtor in respect of its property, including any action under SARFAESI. The recovery of any property by an owner or lessor where the lesser property is occupied by or in possession of the corporate debtor. With all four conditions, one thing is coming out that the property belongs to a corporate debtor or the mortgage created by the corporate debtor. All the assets of the corporate debtor, against that nothing can proceed. Or no proceeding of any execution, decree or suit, anything can proceed against only the corporate debtor.
Not the guarantor.
Well,
not the guarantor.
Not the guarantor. That has been explained. Also, we can see what the law settled.
The respondent here is the guarantor.
Yes, ma'am. The property belongs to a guarantor.
Because the guarantor is not suffering the NCLT proceeding.
Guarantor is not suffering. That's why in the judgment also they have distinguished the section 14 moratorium and section 101 moratorium on the
Because under the sweep of that resolution plan, this property will obviously not come because the guarantor is outside the. Yes.
This writ petition has been filed by DCB Bank Limited, challenging the order dated 25/3/2025 passed by the Land and Chief Judicial Magistrate Quarter in rejecting the application under section 14 of the SARFAESI Act. The Land Counsel for the petitioner submits that since the 14 of the SARFAESI Act application has been rejected, this writ petition is maintainable, and in support of such contention, he has cited the decision of this court in Balaji Financial Limited, Bajaj Finance Limited versus Messrs Ali Agency and others, reported in AR 2022 Orissa 68 Division Bench, wherein it has been held that in case if the district magistrate fails to pass order in terms of what has been provided under section 14 of the SARFAESI Act, or if the same is not being implemented, the secured creditor would have the remedy of invoking the writ jurisdiction of this court under Article 226 of the Constitution of India. The Land Counsel for the petitioner further submits that where have you stated about this guarantor aspect, in which paragraph?
The paragraph 4 I have stated.
Your petition?
Of my petition. That the opposite party 2 is the borrower and opposite party 3 and 4 of the co-borrowers to credit facility advanced to them. The said loan was secured by an equitable mortgage created by the opposite party 2 in favor of the petitioner. The opposite party 2 is the individual. Let's make us see the name of parties.
Shiva Prasad Jana. Suvarakshmi Jana.
The Land Counsel further submits that National Company Law Tribunal declares a moratorium prohibiting the institution and continuation of the suit or proceeding against the corporate debtors, including the execution of any judgment or decree or order pending before any court of law, tribunal, arbitration panel, or other authority. However, the moratorium under section 14 of the Insolvency and Bankruptcy Code 2016 is applicable only against the corporate debtor and not against any other person and or the properties. And the law has been let down by the Honorable Supreme Court in the case of State Bank of India versus P. Ramakrishnan, reported in 2018, 17 SCC 394, that moratorium under section 14 of the IBC does not apply beyond corporate debtor. That is your submission.
Right.
All right. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. No notice be issued to opposite party number 1, Chief Judicial Magistrate Cutter, so far as the opposite parties number 2, 3, and 4 are concerned, requisites for issuance of notice filed within 1 week, matter be placed after 4 weeks. Counter if any be filed in the meantime. Yes. Return the return model sheet. 4 weeks per date was evening.
Item 8.
Item 1. Yes, item number 8. He's seeking for time. So when you want it? Any objection next week? A mention is made on behalf of Mr. Anindya Kumar Mishra, the appellant, counsel for the appellant for adjournment. Mr. Mahantil and counsel appearing for the respondent has no objection. List this matter. Do we commence from 21st government? Yes. Interim order is there. Interim order dated which date?
17/5/2019. 17/5/2019.
17/5/2019 shall continue till next date. Yes. देखिए लोग check कर दो. 17/5/2019 को चल. Yes.
Item 9.
21 तारीख से. Yes.
Proceed in view of order dated 18/6/2025. 18/6/2025.
Just a minute.
The letter has been shown. Outcome is not right, so we should be seen there the transfer, so nothing has been there. Raise some time work.
No, another submission which was made that is the respondent number in that I-8 has been made, IN number 1583, that so far as the existing employees are concerned, payment has been made to the extent of more than 20 crores. These are the employees, that employees of the OSRTC, of course. They are now not in service. So
I am for the appellant. That instruction I have to take. I have to take you to my transfer of the same demand. We have released on 30 man. So if no press appointment has already made.
Key relief na?
CMD man. Chairman from CMD. So nobody was appointed, only charge was given to the additional secretary transfer.
What do you want, both of you? What do you want? Let us say. କୁହନ୍ତୁ ଆପଣ କୁହନ୍ତୁ ସେ ବାରମ୍ବାର ଲିଷ୍ଟ ଆସୁଛି ଅନ୍ୟ ମ୍ୟାଟର ଆସିବନି ନା ଆପଣ ଏଇଟା ଗୋଟେ ଏଇ ମ୍ୟାଟରଟା ହଉଛି 4 ପେଜ ଖଣ୍ଡେ ବୋଧେ ନଉଛି.
Whoever in charge can give also in fact.
ବର୍ତ୍ତମାନ ଠିକ ଅଛି ସେମାନେ ଠିକ କରୁଛନ୍ତି ସେମାନେ ଯୋଉ ଇଂଲିଶ
in the meantime, we filed the other miss case, flag D matter in W170 of 18. Again, they have already implemented it. The RSP 19, they have already implemented. They have already
the organization was running loss. Now they have started.
No, madam. They have already paid
don't burden them slowly. They are paying
30 crores rupees. They have paid to the existing employees. We are concerned with the 31 lakhs.
We are paying, madam. The student 96 revision, whether it is applicable from 96 or 2008. That is the
no, madam. They have already
2008 for
no, madam. They have already implemented it, giving effect from 1196 to the existing employees.
You see,
what they filed in mistake.
So many orders have already been passed. Now it's a question of negotiation between the parties, and it is stated that a meeting has already been taken place as per the order of the court on 6/2/2025. So some decisions have also been taken. What is that decision? What is to be paid or what? All these things the state has to obtain an instruction, and that is how the proceeding, the case was adjourned when it was listed on 18/6/2025. Stated that now the information or instruction has not come, so it may be taken off on some other day. That is exactly the play I have made by.
We have produced, that meeting is already over, that proceeding has been communicated to us. Government
until that communication
ଆପଣମାନେ କହୁଛନ୍ତି internally କଣ ଖବର ନେଇଥିବେ ତାଙ୍କ ପାଖରେ ଷ୍ଟେଟ କାଉନସିଲ ପାଖରେ ସେ ଖବର ନାହିଁ ତ ସେଇ ଖବରଟା ସେ ଆଣିବା ପାଇଁ ବାଇ ୱେ ଅଫ ସେ କେମିତି ମୌଖିକ କହିଦେବେ ବା ଆପଣଙ୍କ ସବମିଶନ କୁ ଆକ୍ସେପ୍ଟ କରିବେ unless he gets in writing from the concerned authority.
That proceeding copy has been communicated to the standing council transport with an instruction that they may approach. That is not been communicated to AG.
Mr. Tripathi is appearing for Orissa.
I am appealing for Orissa. I am the applicant.
He should get the instruction. He is appearing for Orissa.
It was stated that how much the dues would be. That was also, I think that was calculated.
32 lakhs.
32 lakhs.
Only.
They have already paid 20 crore rupees to the existing employees. 5th pay, 6th pay, 7th pay, they have cleared up. Another 15 crore rupees will be paid to the existing employees.
Details.
32 lakhs pay and finish it up.
Only 4 weeks time.
4 weeks time, this is a matter yet in 96. Now it is 25. 30 years has passed. No. 30 years has passed.
All right, Land Council for the state as well as Land Council appearing for the OSRTC from the appellants. Take some further time to obtain instruction as per the previous order of this court. Put up this matter. Use of the for a proceeding.
They may take instruction IA number 3005 flag D.
IA number
3005 of 25 flag D of WFI 170.
Again, a huge amount has been released in the meantime.
WA number kete kon
3005.
The
IA number 170.
Ticket ho tu tator hai kandi ho.
WA number 170 of 2018 years.
पैसा थुआ जानी दे देवे ना कौन को नंबर टा डब्ल्यू एटा पाउन हमें एड़ा इत्ते वासिले
170 जो
170
170 of 2008
Second item.
170 रे आईए नंबर कोडा कहउजंदी
3005 flag D.
डेटा लिखिए आईए नंबर so and so this is an application for appropriate order.
Right.
Let a copy of the interim application be served. This was filed by whom? This IE has been filed by
the respondent.
By the respondent. Let a copy of the interim application be order copy of the interim application be served on the Land Council for the appellant, and we shall obtain instruction on the interim application. Baki sobuda with years.
Yes. Out of
already solved.
Out of this.
Another copy already solved.
Already solved.
Yes. Copy interim application already solved. Yes.
Item 10.
I'm for the petition. Yes, I submitted a note to the Lordship. This is challenging an order of the DRAT, reversing the decision of the DRAT. It was passed in my favor, in which I had challenged the sale of my property. The DRT had allowed set aside the sale. The bank went up in appeal, and the DRT has set aside.
you are, Mr. Mahat, you are appearing for the petitioner. And how many opposite parties are there? There's five. No, 5 means limit those debt recovery tribunal के छाड़ दिया हमको. अभी 1-2 छाड़ दिया हमको. बाकी रहना State Bank of India बैंक की आपके.
3 years. I am along with Mr. SP Mishra, senior advocate.
Okay. So 3, 4, 5. 5 टा हो जी.
5 was auction purchase.
हाँ, अपन appear करो. So what has been challenged here?
The order of the DRA, the appellate order of the DRA, the reversing decision in which
you approach the DRT.
no, I approve, sir. Yes, I approve the DRA.
What is the order of the DRT?
Annexed 2.
Annexed 2. Why you approve the DRT?
For challenging a sale of my property in a recovery proceeding on various grounds. I will place that. I had given a note with your lordship.
We will see just. Then what order was passed by the...
Order was passed satisfied the sale. Your lordship may see kindly page 64.
That sale certificate dated 2017 was quashed. And it was directed
with certain directions.
With certain directions.
And those directions were complied. I deposited the amount and all those.
Is it correct?
Yes.
Okay, yes.
Then the bank preferred appeal.
Okay.
In the appeal, the appellate courts reversed the order.
On what ground it was reversed?
On the ground that that my allegations that there are separate NPA dates given in separate notices, that is immaterial. So therefore, and I have not challenged, one very technical ground he has taken, that I have not challenged each notice. I should have challenged each notice before the DRT. My claim was consolidated under section 17. Okay.
But the entire debt is paid back.
The entire debt is paid back. I will come to that because that there the crux arises. Your lordship has also taken note of that fact and placed that order also. But here it is necessary before I proceed with the case plot to know what was my case before the DRT. On what grievance I approached the DRT.
So if Mr. Udgada,
yes.
So the man who was the, if he has already paid the amount as per the order of this court.
And by virtue of my lord's order also, we have already refunded that amount.
The excess amount.
Entire amount we have refunded.
No. The first it was sold. The due was 24 lakhs according to them. It was sold for 29 lakhs. My initial grievance was that if you have realized the amount, why didn't you refund the balance?
Balance amount.
They did not do this. Thereafter, when the DRT allowed in my favor, at your lordship had seen, directly deposit of 25, I deposited again 25. I deposited again 25. So when this matter came up before your lordships, courted bench of your lordships, they made a submission that will refund that. That excess plus 25. That your lordship will find order dated 19/7/23.
But in the meantime, they have already sold the property.
Sold the property to the finance.
That
That sale was challenged. That sale was challenged before the.
Main thing that whether at this stage redemption can be made or not made. That is the section under section that redemption of the property can be done or not made under section 13(8) of the SARFAESI Act.
When that man sold the property.
When he purchased.
When he purchased.
Purchase is.
This opposite party number.
Minutes 17 minutes.
5 Manoj Kumar Das.
Minutes. Page minutes of my counter 49. E-action sale notice minutes 18/4/17 and sale certificate has been issued minutes since 12/6/17 minutes. And registered sale deed according minutes also executed since 17. At page 52 of my counter minutes. sale deed has been executed.
When was the DRT proceeding started?
Yeah.
When the DRT, he has approached DRT?
They have approached minutes.
So 2018 you approached, that's it.
Yes.
After the sale.
Yes, sir. Challenging the sale. Challenging the sale I had.
When they have the minutes deposited after the minutes judgment passed by the DRT minutes.
Yes.
The question of redemption does not arise.
DRT directed me to deposit. That's why it is
That has also been dealt by the appellate court.
But 24 lakh rupees was
due.
Due and you recovered it through sale.
Yes,
That
we
is
have-
29.
Yes.
So for the 5 lakh rupees which was extra has to be refunded, and pursuant to the DRT direction 25 lakhs extra he has deposited.
That has already been done. Yes.
Done.
He has done, but we have refunded the entire amount they have deposited.
That is by
By virtue of the order of this on court.
They did not return
So
it.
at this stage, what can be done?
But I'll just come to it.
The property has already been sold.
This property has been sold, but if the sale is.
At that point of time, you could have very well approached the No, you approached much after.
2018.
2017 was the sale. You approached the DRT in 2018. So, because prior to that, this 13-4, all these proceeding would have been there. So at that
No.
stage, you could have approached the DRT,
No.
but you did not.
I have given the date of knowledge as this.
Mhm.
Your Lordship sees the dates. 18/4/2017, the advertisement was made for sale. 18/4/17.
Hmm.
That was during the subsistence of a status quo order passed by the court. Right? Now, after that, if the
Which court passed the status quo order?
this is first the civil court, thereafter this honorable court. I'll come to those dates.
No, if in spite of status quo order, they issued such notice, why didn't you bring it to the notice?
No,
of the-
I did not know. I did not know that the civil court had passed an order of status quo on 6/12/2016. When SBI filed on 27/12/2016, this OA claiming 24 lakhs, somewhat, against me. And they put, despite that status quo order, they put the auction sale, and the Honorable High Court passed the order on 12/5/2017. Notwithstanding the status quo order, the property was sold. This is my sole contention. Now, under such background, sale certificate was issued, despite the subsistence of status quo order. I was not, it is the State Bank who was the party.
When the status quo order was passed, the bank must have been a party in that proceeding.
Bank is a party.
And it was in the knowledge of the bank that status quo order has been passed. That is your submission. But no step has been taken to modify that order.
No.
But they in turn proceeded with that
Sale. Issuance of sale certificate, etc.
Is it correct?
It is correct, and we have also minutes brought all these things before the honorable court minutes, and in CMP number minutes 586 of 17 minutes, and it was disposed of without any minutes adversary against the bank minutes, and ultimately because we have brought to the notice of this honorable court minutes that yes, we have sold this because it was not in our knowledge at the time of sale of the property minutes.
No, how can you say you are a party to that proceeding status quo order was passed?
Exactly.
And you must be deemed.
We are a party, but we have not been noticed minutes. We have not been noticed. Yes,
That is why we are asking the party that whether you have already entered appearance in that.
No, we have not entered appearance minutes.
That is the main, that goes to the crux of the, that goes to the root of the matter. Suppose the bank was aware about the status quo order passed by this court. This court has passed.
We are not aware. Our contention before the
record is there. The Lordship may kindly see. CNP 586 of 2017. The Lordship had called for the record.
CM?
CNP 586 of
2017.
2017.
Status quo order dated
12/5/2017.
12/5/17.
12/5/2017, it indicates that a copy of the petition be sought on Counsel, who usually appears on behalf of the State Bank of India in course of the day. Then issue notice to opposite party number 2. Who is opposite party number 2?
Who is the bank minutes? But Mr. P.V. Balpiston, Urship Takabi did not inform the bank minutes. That is the thing. for which minutes we could not know about the fact of the status quo order passed by the Supreme Court minutes, and during that period we have sold the property. And immediately minutes after coming to know about this fact minutes.
No. Are you disputing that Mr. Balkrishnan was not in the panel at that point of time? So if that is in the panel and the order has been passed by a court that to serve a copy on a particular counsel, and if they have complied the same, then it was supposed that he should inform the bank that this has the order has been passed. So if it is not been done by your counsel, then the matter was taken off again. You see, on 6/9/2000, when the sale was confirmed in his favor, opposite party number 5.
That's on 12/6/17 minutes.
12/6/17
minutes.
Prior to that, the status quo order was there on 12/5/2017, and it is specifically mentioned that as an interim measure, the parties are directed to maintain the status quo order over the suit property till the next date. And the next date comes on 6/9/2017. Right?
Yes.
In 6/9/2017, the name of Mr. Balakrishna we deleted from the so-and-so, undertakes to so-and-so. You see, he perhaps has been served with a copy of the writ petition. And
Lordship, just a glance to the counter affidavit at page 89, Lords, running page. Mr. Balakrishnan on 17/6/17 intimated the bank about the fact of status quo minutes. By the time minutes we have already issued minutes the sale certificate. And immediately after that minutes, we have filed our counter affidavit before the honorable single judge. That is at running page 90 minutes. Annexure K3 minutes, wherein your Lordship and
Mr. Mahanti, when this copy was served,
That's what
12/5/2017 order ଅନୁଯାୟୀ ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଯେ in course of the day.
In course of the day. Surveys.
Where is that proof?
Record must be records are called for that reason. One thing your Lordship may kindly note that we were not parties. The present petitioners were not parties. Petitioners were not parties.
In which?
Suit was filed by a third party against the state bank. In this respect of this property, and this property's status quo order was passed.
That means petitioner is not a party in the CMP minutes.
Yes. Yes.
How then you came into picture?
But that is what I'm saying. When this status quo order was passed,
That was passed in one Samarendra Nanda was the petitioner.
who filed a suit against the bank in respect of the same
By
property.
virtue of a minutes.
How you came into picture?
My property. It is my property. That's why. There was an agreement for sale with this Samarendra Nanda. He filed the suit. He filed the suit against the bank.
And he got a status quo order before the Miller's Lorraine district judge minutes. Ultimately, we appeared before the Lorraine district judge, and that status quo order was vacated minutes. Against the bank minutes.
Thereafter again he came here
Minutes.
and got it.
And all these minutes, that is collusion minutes, and ultimately minutes.
You, Mr. Udgar, has entered appearance in GMP on 10/8/2017.
And he had also filed another minutes civil suit before the subject banking minutes, and he failed also there. Because only to in order to avoid to repay the loan outstanding minutes. This is the conduct.
No, avoid means this property has been sold. The loan has been satisfied.
Loan has not been satisfied. When because by
He has already you have already returned the entire dues of that which he has deposited.
Yes,
apart from the extra amount which he has received.
By virtue of a lordship.
We have already minutes brought to the knowledge of the Supreme Court that this order is not sustainable minutes, and by virtue of the order of the Lorraine DRT minutes, we have received this amount minutes. So that may be refunded minutes. Ultimately, when we won the case before the DRT, we make a prayer before the Supreme Court that let a direction be given to refund that amount. And ultimately, the Supreme Court has pleased to minutes directly to refund that amount minutes. So they have not satisfied the minutes, the loan outstanding, and the option.
No, we are putting you a question as to whether that amount has actually been refunded or not?
Actually refunded, that is the admission there.
By
They
virtue of
can
your
be
lordship's order passed in this court.
Yes.
Because they did not refund it at that point of time. They kept it. When the matter was brought to the notice of this honorable court, the lordship directed and they said, yes, we'll return.
This CMP was filed by so and so.
Yes.
What was the link? That means by that time, how this man got any right?
He said that he has entered into an agreement for sale of the same property with me. So the bank should not go for sale.
What is that the government has been taken in that respect?
Yes, sir.
Which paragraph?
This is civil suit. I have given the civil suit also.
No, in the writ petition,
15/7/2016, the suit was filed. Nothing at page.
no, you see, the government is something different what you are submitting.
Well,
Samarendra Nanda, have you got the copy of that CMP? CMP रो जो अपन समरेंद्र नंद जोटा पास करते जितने स्टेटस को ऑर्डर पास है तादेर देखुन से कौन लिखी जी आपन कथा तो टोटल से किसी कहूनी से कोची जे plaintiff's case is that he is also the plaintiff in that
yes,
right.
in the suit.
So he said that the property belongs to defendant number one. Defendant number one means the bank or what? Yes. Who had and purchased it from one Hare Krishna Das. Nothing has been stated that there was any kind of.
But the property is same.
Question of your right now comes into that. Who are you?
Well, I'm the owner of the property because they have sold my property now for realization of my use. That's the mortgage property.
That order was passed in favor of Mr. X, and X has no grievance at all now.
No, X cannot have any grievance now because his CMP has been dismissed.
So,
and I don't know about this suit, what has happened about this suit.
I hope that you have got a copy of the CMP with you. Please go through it.
CMP.
Whatever is submitting that is totally different.
No, what he has stated, Samarendra has stated. Lordship is.
He has stated that as he has that bank was agreed to sell the suit land to the plaintiff in C for consideration of so and so, and he received the amount of rupees 1,10,000 so and so. You go through it, that would be better. So if you have not got a copy, because your submission is completely contrary to the
what he
readings
has
of it.
Was he has stated.
Yes, that is why. CM जो थरा अपन status को order टा अपन एते हार करूचंदी ना तार pleading टा देखो तो अब अपन को submission वर्तमान जहाँ टा करूचंदी.
Yes, I will go through it, but only thing is that I want to say that the property in CLP, property here are the same. Status quo was order was passed in respect of the same property.
Mr. Balakrishna had appeared on that day with the status quo.
But that is what the
it appears that advance copy was served on him.
Served on him.
On 12/5/17.
Their only stand is that the lawyer did not inform.
That's right. But Mr. Balakrishna had accepted the advance copy
Advance
and
copy.
appears to have appeared also.
That's
Looks
what I'm
like.
saying. It is, he says, or the bank says that he informed them late. But that, for that, no one can be responsible for.
That's the reason on 6/9/2017, after the sale is confirmed, and he was asked to, be released from the
Some other counsel.
Mr. Udgata then files Vakalatnama.
Well, not from that. But that is an internal arrangement between them.
No. They knew that this particular question would be put, and they,
So therefore,
once they take that counsel out of that, then this ground can be that he informed late. Now, otherwise he would have appeared, would have put the question to the Mr. when you intimated all these things.
They have squarely put the blame on Mr. Bhatt.
Right.
That's the only gist of it.
But you are contesting the suit. You are contesting the suit.
I have questions.
And you must be knowing that if the stay order is vacated, they will be approaching the court. Higher court. It's a continuation. It's a continuation of the proceeding. You can't very casually say that some lawyer is appeared and thereafter you remove him, put someone else.
It's just shifting a blame to a counsel. Nothing else.
It is not an original proceeding. CMP proceeding is not an original proceeding. Original proceeding is suit proceeding. Suit proceeding, there was a stay operating. Somehow it was vacated. Against that vacation order, they came here. Then it is a continuation. The bank should be responsible.
Because he's a third party minutes. He's not a borrower minutes.
That's a different story. I was talking about the status quo, whether it was under the knowledge of the bank or not. It was very well under the knowledge of the bank. Despite that, you went ahead.
It is not within the knowledge of the bank.
And we hear the matter and pass an order writing, suppose that so-and-so counsel has not intimated the bank. And we are without hearing him also. Without hearing him, if would have been given, he said that I had intimated in time. So we will pass the order without hearing him that he intimated not in time, and that is how the bank.
It is also admitted by Mr. B. Balkrishna that he has intimated late minute. That is it is a fair leave. Because question of having the order of this does not arise minute. If we are Miller's law-abiding citizen, question of.
But you see, the bank, in one hand, you have taken back your entire money.
No, we have never taken.
24 lakhs you have taken?
No, we have.
After auction, 25 lakhs, 24 lakhs you have taken.
DRT compels us minutes because.
Whatever, you have taken your money.
You have taken money from them.
And put these people into trouble.
Now, you see, status quo order is also in respect to the property. You now created another party, accepted the money. Now you are returning the money. What about him?
You also can find from.
They are in the also problem. He is also problem.
Because we have never even minutes registered to sell it minutes. Though we have sold the property, we have never minutes. After disposal of the CMP, we have minutes registered to sell it minutes. Because we have brought everything before the unknown single judge. That minutes, this is the minutes thing minutes, and Mr. P.V. Balkrishna has not minutes. From our counter affidavit notes in the CMP. From the CMP also have find that notes, we have brought everything before the only single judge notes. That really this is the fact notes, and PV Balkrishna has never intimated.
But the lighter side, I was just telling my brother whether the recovery officer is somehow related to the auction purchaser. Maybe just verified for your interest.
Because that cannot, because one of my grounds is that the suit property official valuation is about 84 lakhs. It has been sold by.
That's how it happens.
But
over enthusiasm.
How much money you got from
29 lakhs.
29 lakhs. And by the time we recovered, the loan outstanding is much more than 29 lakhs.
No, 24.
24 lakhs.
24 plus interest, further interest.
No, 24, they executed they filed a case for realization of 24.
That's the reason 5 lakhs you have returned. 5 lakhs you have returned out of that 29.
Yes.
Retaining 24, 5 lakhs you have returned.
No, the order of the DIT was that not supposed to a glance.
But have you challenged that order?
Yes, minutes, before the DRT minutes, we have challenged this.
But the bank has returned not only the
No, that 24 lakh.
lakhs, they have not yet returned.
No, we have returned.
No. 25 lakhs subsequently you deposited. Yes, that's what
5
he
lakhs
said.
pursuant to the DRT order, they have returned.
Huh.
The differential 5 lakhs they have returned. But they have appropriated 24 lakhs for which they had filed the execution.
That's right.
For the sale. Because they put the property to auction sale for that purpose.
You were asked to deposit 25 lakhs, which you had deposited.
Yes.
So that money is refunded and the differential amount of 5 lakhs. But 24 lakhs they have taken.
Yes. Because they wanted to realize 24 lakhs odd from the sale and they got it. Well ahead.
Perhaps I mean minutes, in a clear minutes. We have filed the original application for 24 lakhs amounts plus interest and cost. And the original application is also allowed minutes for 24 lakhs amounts and plus interest and cost minutes. That I can produce that original application, the certificate minutes. That is the order of the loan DRT minutes. And accordingly minutes, we have realized that is coming on above 20 lakhs minutes. The question of surplus does not arise.
So how did they return that for 5 lakhs if the dues were more?
No, that interest would have been adjusted.
We have refunded whatever the amount you have deposited. We have
No.
5 lakhs also. That's the case.
Also, this differential amount also. Your Lordship sees the order.
If had there been any interest, you would have adjusted with that 29 lakhs. 5 lakhs, why have you returned?
Just kindly see, this is not correct, which is 19/7/23 order. Again, sorry for repetition, 19/7/23 order. Mr. S.P. Mishra and Senior Counsel appearing for the opposite party bank contended that so far as the demand raised by the bank on the petitioners for an amount of rupees 25 lakhs, the same has already been realized from the sale proceeds of the property of the petitioners at 29 lakhs, and therefore the bank will refund the balance amount of 4 lakhs to the petitioner. So far as the demand raised by the bank on the petitioner 25 lakhs, the same will be refunded. So two different things.
Two different things. We have refunded only 25 lakhs.
No, 5.
No, we have not refunded. This is, I am correct. I am fully correct. You just ask your client what he has received. He has not received any surplus amount. Only he has received 25 lakhs. The amount he has deposited by virtue of the order of the loan and dear.
Seta katha no book paisi ki your Lordship, he is what's your Lordship kindly sees. But for his
by virtue of which order you have deposited 25 lakhs? You have deposited by which order?
Annex 2, page 64.
No. The 27/2/2023 order. Just check third paragraph. Therefore, the balance amount of rupees 5 lakhs and some order has to be refunded also. But instead of doing so, the petitioner were called upon to deposit a sum of rupees 25,000 lakhs, and which was deposited by the petitioner before the bank.
Yes, that is by virtue of the DRT order.
And I have filed
two separate deposits. It may not be there may not be any overlapping. Two different deposits. One by virtue of the order of the DRT, 25 lakhs we deposited. One by virtue of their realization upon sale, 29 lakhs. So 29 lakhs, they sold the property, realized their dues, and refunded me. The counsel says that, the order says that, refunded the backup. At least agreed to refund the. They could have stated no, there is no question of
interest component is there, we will adjust.
Lordship, I have filed minutes, IN number 16130 of 23 minutes. Lordship, glance minutes. I have also served a copy since long minutes, since 23 minutes. Wherein I have clarified the position minutes. What is the amount to be refunded? And for clarification order of this one court. I get a file 1613023 on 18/9/23. I have served a copy on 9/10/23. And they have not filed any objection to this.
Anti, do one thing. you take the entire records of CMP 586/2017 in the pen drive.
Yes.
Just give the pen drive, they will hand it over to you and go through it. We can take up this matter after 2 days or 3 days or time. Please go through it because, and another thing that if a status quo order has been passed and the council is aware of about it. So merely because the concerned council does not intimate the bank whether the bank can flout the order of this court status quo order and sell the property. It is the laches on part of the, let us say, panel council, 5-6 advocates are there. One order was passed and it was supposed to be communicated by that panel council to the bank. And in spite of the status quo order, the bank proceeded and sell the property. So can the party in whose favor the status quo order has been passed, he will be suffering merely because your council did not intimate your bank in about their status quo order, even after receipt of the copy. The entire thing goes to that stage. If the property is different, matter is different. Yeah. But what Mr. Mahanti says that the CMP property is the same, very same property, which is the subject matter of this writ petition also. And also before the DRT and DRA.
The property which was sold.
Right. So.
At the same time, you consider paying back 29 lakhs to and persuade them. They'll take back 29 lakhs
yes, I am ready to.
Along with some interest.
That's what I'm saying.
In 2017 they have paid.
Yes.
They are entitled to interest. 29 lakhs plus interest paid to the auction purchaser.
The person who has now paid the amount, if you are agreeable to pay back that amount in the differential amount, of course.
Of course. And with interest.
With interest.
At least you consider that.
Sir, my submission prior to this honorable court is that being the auction purchaser and sale certificate as well as this registered sale deed has been in my name. So where is the right of redemption of the petitioner in that case?
No, in view of the background of the case, because that could not have been put to auction. Question goes to the root of the matter. In view of the status quo order passed by this court, the property could not have been put to auction. They have done it.
That is the
so you proceed against the bank. Ask for file a damage suit against them.
That's it.
That's the case.
That is after honorable.
That is just giving in.
But another thing is that, Lordship, the person who has filed this CMP, how his
that is how we are asking him to go through the that CMP records. Let him go through it, and we also do not find any. You also go through the CMP records. What is the link between this petitioner and the petitioner who was there in the CMP?
Because my lawn friend has intimated honorable court that as he has done a mere agreement, sale agreement.
Where is that agreement? If we do not find, we can say that it is a mere statement, bald assertion, no documentary proof in that respect. If there is no averment in the writ petition also that he has got any link with that petitioner in the CMP, then matter goes there. Only he say that only that in respect of that property, but that person is not aggrieved. He is not before us. At that Sambedana or something like that. So both of you go through the records of CMP 586 and the submission which you have heard from Mr. Mahanti, and just study it and but take the records in your pen drive. Once this matter goes out of the list, it may be difficult on your part. Just give your pen drive and take it.
Pass an order that so that we can get.
Mr. Mahanti and senior advocates, also the land council appearing for the bank and the opposite party number 5 submits that they may be given a copy of the entire records of the CMP 586 of 2017 in their respective pen drives, which is not available with them. Let the registry supply the same in the respective pen drives. Put up this matter. Record. Let it come a week after or something. Week after.
As per your worship's
21st July 2025. Yes.
Item 11.
Interim order
is there. Interim order to continue till next day.
Item 11.
This is last order. They have to file, haven't.
You want, you have gone through this, he is serving. Yes. No, any objection to the amendment or you want to go through?
Amendment to be formal that may be allowed,
Give it to you. Just a minute.
may be posted to some other day.
Just like on IN number, it is registered in IN number so and so, there is an interim application filed in the court for amendment of certain paragraphs of the writ petition, source of grounds taken in the writ petition. Copy of the interim application has been served on the land and council for the opposite parties. Let the IA be registered. Stop. The land and council for the opposite parties submit that they have no objection to the prayer made in the interim application. Accordingly, prayer for amendment is allowed. The bill of amendment now shall form a part of the writ petition. The land consolidated writ petition अच्छी अपन आनी चाहिए अच्छा के भी फाइल करिए गोटे सप्ताह हाँ
2 to 3 articles.
So by next week file going. The land council for the petition will submit that you will file the consolidated writ petition by next week. Put up this matter. Give a copy on the land council for the opposite party. Put up this matter. What is up top for also by next week?
28 commencement on 28.
21st.
28.
28th of July 2020.
Okay.
Item 12.
Please, my lord, here,
Register for the register for register for नंबर टा पड़िबो ना तो जेरे आइए नंबर टा ठीक है ये
please, my lord, here.
this is that matter
Regarding getting an appointment under the compassionate ground. My lord, they don't have any objection last occasion also, only awaiting that order to be passed by my lord.
No, that is not correct.
Not correct.
Matter was heard also.
Not correct.
Then they file, then they, after your lordship observe that the order has not been challenged in the prayer, then they have filed amendment and
Amendment was allowed. Amendment was allowed. My lord also posed a question that if you have given appointment on compassionate to other employees, why not to me? That is there. They said that we cannot consider, but awaiting the order to be passed by my lord. That was there.
No.
The last occasion also.
Tribunal has rejected also, has considered this.
Against that, we have also preferred this writ petition.
The question is that whether there was any such scheme which is there for grant of compassionate appointment to the legal heirs of the deceased, because now you seek for compassionate appointment of whom? There are two petitioners.
Dr. Resma Behra.
Petition
number 2.
Petition number 2. So their father was Mohan Behra. The petition number 2's father was Mohan Behra.
Yes.
So there is no dispute that he was an employee.
Regular employee.
Of that Nagpur.
Yes.
And he was serving a chargeman grade 2. Right? In the Smelter Division, so and so.
Yes.
And
The last occasion also, the another.
Just a minute, let us recap to that thing there. Yeah. Then he was given promotion, so on, so, okay.
Your Lordship may see page 40 of the petition.
He was
Discharged.
He was discharged from service.
Thereafter he has been reinstated.
Just a minute. We are going to upon.
Sir.
Then a decision was taken to reinstate him in the service.
Yes, we were directed to consider and reinstate. Lordship may see page 17. We made him an offer that you come and join. 8/12/2011.
That is 8/12/2011. Okay.
Page 17. He did not join.
450 ke padile tadile.
Lordship.
Based on your representation to the chairman.
National Commission, as per advice of the Honorable Commission, as a measure of benevolence, you are offered an engagement as operator technician on a consolidated pay of this much. Then you also may see the second last paragraph. On your joining, you will be governed by the rules and regulations of the company in matters of employment and conditions of service. After this, he did not reply to this, nor did he join. Subsequently, after 6 years, your Lordship may see page 22. This was in 2011. After 6 years in page 22, he gave a representation, you consider me, you reinstate me now. That we rejected at page 22.
This is 9/9/2017.
Lordship. This he challenged before the tribunal. This was pending. At the time of pendency before the tribunal, he expired.
Yes.
And the legal head, then they got substituted. They have withdrawn the petition from the tribunal also. So this issue has remained final. Since 2011, he was not an employee. And our scheme says that only if he has an employee and during course of employment, if he has died, then compassionate appointment will be given. That is our scheme. Based on that, they filed a petition before the tribunal. Tribunal also rejected on that ground. That
Where is the order of the tribunal?
Tribunal also directed to consider the case.
Page 29, paragraph 4.
And thereafter they withdraw.
29. Okay, paragraph 4 in
paragraph 4. In the facts and circumstances of the present case, when the ex-employee has been discharged from duty by order dated 16/2011, this tribunal finds that no illegality has been committed by the respondent's organization in refusing to give compassionate appointment in favor of the applicant number 2, who is the daughter of the ex-employee, since the said is not permissible as per provision of NALCO. And in the writ petition also, they are now challenging this order. There is no ground which they have raised challenging this finding as to if there is any infirmity or illegality in this finding. There is no ground raised also in the writ petition.
The dismissal or the termination order was never questioned.
No.
Rather, it was questioned in the tribunal and it was withdrawn. So then the termination order has become attained finality.
Lordship.
So he is no more the employee.
No. Since 2011, he was not an employee.
And question of compassionate appointment is arises only as per that scheme.
That scheme is there, very well also available. And also basing on that scheme also, they have given 9 to 10 persons under that scheme, appointment under that scheme.
You are removed from service. You did not join, and you were asked to join. So thereafter you did not, and whether in such a situation the scheme would be applicable in your case.
Sir, difficulties I have stated that when they have removed me in service and thereafter I also that removal order also set aside. Then his mental condition was also not good, and he was also
page 50, na?
56.
56 of the counter order.
Yes, this is part of the counter. This is a compassionate appointment scheme. Lordship may see the serial last 3 paragraph, serial number 1. The employee and employment on compassionate ground will be considered only on accidental death cases which comes under the category arising out of and in course of employment as per provision of Workmen's Compensation Act. Compassionate appointment will be offered after being satisfied that there is no other means of livelihood of the family of the deceased employee. Compassionate employment can be confined to the post in non-executive category and induction level and against available vacancy. The dependent wife, son, daughter of the deceased may be considered for employment. And all these, it is not all. So all these have to be satisfied. So the once she is not coming under the first category, that during course of employment, her father should have
in course of employment, because
How do you say that?
because he has been reinstated. He has been reinstated.
He has not.
Thereafter, he has not been removed from service. He has been after reinstatement. He has not
passed in your favor to come and join.
because
But you did not join.
because his mental condition was not good. For that reason, he could not join.
See,
Thereafter,
2000, see, sequence is 2011, after you own the case, you were asked to come and join. You didn't join.
no, I joined.
1 minute.
Sir.
In 2017, these are the record. In
Sir.
2017, rather you given a representation, which was rejected.
Yes.
That rejection order you challenged before the tribunal.
Yes.
And during that pendency, your father died.
Yes.
And you people have withdrawn that.
Because
if you would have challenged, you would have succeeded.
No,
would have been
in
different.
the Central Administrative Tribunal, the proceeding, discipline proceeding was under challenge. Because the tribunal also held that you are not the competent person to challenge that disciplinary proceeding of your father. For that reason, that has been withdrawn.
Moreover, see, compassionate appointments are to only to take care of the vagrancy. Okay.
Sir.
2011 death. Today we are in 2000.
No. Death was 2021.
Not given.
Sir, death was 2021. 15/4/2021. Death was there. When the matter was also pending before the Central Administrative Tribunal.
Today we are at 25.
Because the matter is also still pending.
Yes, Mr. What do you say?
Sir, initially the Central Administrative Tribunal also directed to consider the case of the petitioner for giving an appointment on the compassionate route. Thereafter, they have not considered. Again, I have also moved to the Central Administrative Tribunal, and also that has been withdrawn because the proceeding was under challenge. At that time, the father of the petitioner was not there. They say, the Central Administrative says, no, you cannot challenge the proceedings of your father because he too challenged that proceeding.
We asked you to take some instructions.
Yes,
whether it is
was directed. Subsequently, I also informed that I have taken instruction. Since she is not coming under the scheme, it's not possible to consider. Because only we have giving appointment on compassionate appointment only in cases when they're coming under the scheme. And on there are various judgments also there.
11. This writ petition has been filed by Manoranjita Behera and Resma Behera.
Sir, may I draw my lordship's attention on this?
Considering the appointment of the petitioner number 2 under the compassionate appointment or rehabilitation scheme available for central government employee public sector rules. Stop. The factual scenario as depicted in the writ petition indicates that the husband of the petitioner number 1, who is also the father of petitioner number 2, namely Mohan Behera, was an employee under the opposite parties. And he was discharged from the service by the opposite parties, and by the order dated 19/10/2011, passed by which commission do you say?
National Commission for Scheduled Caste,
Acha.
page 16.
National Commission for Scheduled Caste, comma, the opposite parties were asked to reinstate Mohan Behra in service. National Scheduled Caste Commission, New Delhi. Hello? Stop. It is the case of the petitioners that in spite of the order passed by the commission, the opposite parties offered him a fixed tenure service appointment. In which the salary was less than his original salary, for which there was mental disorder of Mohan Behra, and he could not join the services, and he filed way number 820 of 2016 before which court?
Central Administrative Tribunal.
Before Central Administrative Tribunal.
What of which?
Challenging the punishment which was imposed on you.
No, giving an appointment or compassionate wrong.
What is the prayer made in that way?
5, sir. Para 5, please see. Having heard the applicant number 2 in person and Roland Senior Counsel.
Para 5 of what?
Para 5 of that judgment. 820 of civil 16. OA.
Annexure?
Annexure 7.
Just a minute. Wait.
Para 5.
Just a minute.
That OA was filed by the employment and the father of the
father of this.
Father that had filed OA 625, that we had rejected after 6 years when he gave a representation to take him back to service. That we had rejected. That was challenged. That was challenged in OA 625.
OA 260 of 2015. Challenging
challenging our letter dated 9/9/2017, page 22.
Challenging the letter dated
9/9/2017.
9/9/2017, passed by the opposite parties.
No, sir.
And what was that letter?
Rejecting the representation to take him back to service because he filed a representation after 6 years.
Rejecting the representation of so Behera in taking into service as it was filed after
6 years.
6 years. The learned tribunal disposed of the original application
that was withdrawn. That OA which was filed by the father of the
yes, that was the father of the
that was withdrawn subsequently.
But MR Behera order ta pass is
that is a different proceeding. They filed a prayer simultaneously. They filed a petition to consider compassionate appointment.
That was 820. 820 of 60.
Direction that
para 5, sir. Para 5. Having heard the applicant number 2 in person and the London Senior Counsel representing the respondent authority, I do not find any document on record on the basis of which the prayer.
Just a minute.
Sir.
And the say you waiter number ta kete se joda file karthile apankaro joda apan reject karthile ta way number kete
346.
That was OA number 260. That was 260.
No, 260 to samastar common number ta 260 roji ta par jo number ta. And he has not given that. Say you order ta apan deina di.
There were 2 OAs. One
Annex 10, sir. Annex 10. 346 of 70.
346 is the impugned order.
No, that is impugned order. Annex 10.
346.
820 of 2016 re. The order was passed. That in case there is any suitable vacancy under the NALPO, and if any application is made by so and so Behera, then if it's found eligible for such post, the same may be considered by the respondent authorities along with other cases. So far as आपण जो order टा pass करथिले जोटा reject करी सेही गोटा का दरकार नहीं एटा तो अलगा जिनसटा हैगला बाकी सेटार order टा काहे जोटा आपण कहउछन withdraw कले बेली काहे सेटा
The withdrawal is page 54. That was the OA filed by the father of the.
See, father of the court. Where is that order?
The order is not on record. The withdrawal petition is there at page 53.
Where is the averment at least?
Page 53, the withdrawal petition is there. That petition.
53.
Lordship.
53 in the counter.
Yes, it's part of the counter.
That is MA.
OA number 625 of 2017.
17.
Yes.
Say number 625 of 2017, in which the application rejected. And that was challenged before the tribunal in OA number 625 of 2017, and it was withdrawn. Stop. ये जो प्रेजेंट रिट पिटिशन रे आपण जो ऑर्डर टा चैलेंज करछन सेटा को ऑर्डर टा
that is orders 6/10/2021 in 346 of 2017.
Yes,
page 27. Annex 10.
In the present writ petition, challenge has been made to the order dated 6/10/2021 in OA number 3 46 of 2017, in which the tribunal dismissed the original application, which was filed challenging the refusal of the opposite party to give compassionate appointment in favor of the petitioner number 2, who is the daughter of the ex-employee, on the ground that it is not permissible under the provision of the NALCO. The Land Counsel for the opposite parties has filed counter affidavit and placed the scheme for compassionate appointment, which is dated. What you can say scheme ta kahin?
Page 56, annexure C/1 of my counter.
Just which is annexed as annexure
C/1.
C/1 to the counter affidavit. Which states inter alia that the employment on compassionate ground will be considered only on accidental death cases, which comes under the category of arising out of and in course of employment as per the provision of Workmen Compensation Act. It is the contention of the Land Counsel for the opposite parties that since the father of the petitioner number 2 was not an employee under the opposite parties, and he was discharged from the service, and in spite of the order of the commission to reinstate it in service, he did not join the service. Therefore, the scheme for compassionate appointment is not applicable to him, and that is the reason why the Land Central Administrative Tribunal has rejected the original application. After hearing the Land Counsel for the respective parties and going through the scheme as formulated by the opposite parties under the heading of employment on compassionate ground, and since we find that the father of the petitioner number 2 is not coming under this scheme, and the original application which was filed by the ex-employee, the father of the petitioner number 2, was withdrawn from the Land Central Administrative Tribunal. Therefore, there is no illegality in the impugned order passed by the Land Central Administrative Tribunal. Accordingly, the writ petition being devoid of merit stands dismissed. Now,
I have mentioned. Yeah, after conviction bail matter null, jail custody since 12 years null. It's buying for bail, criminal appeal for bail, life.
Supplementary list item 1. Weekly list item 1.
Appellant convicted under section 302 and other offences.
Right, admit call for the trial court reform. Interim applications for bail and stabilization of fine to be considered after receipt of the trial court reform. Deposition copies of the witnesses be supplied to the land council for the state in the meantime.
If I may be pardoned, I have filed my wakalatnama. I am appearing on behalf of the deceased wife, my lords, in this item number 1. Let them serve me a copy of the appeal.
In the first appeal or all the?
Item number 1.
Let a copy of the appeal memo be served on the land council. Here.
Item 2.
Admit. Release to the or we judge severe admit.
Item 3.
Them life in
Life has modified term.
Item 4.
May I
Item 5.
Please,
17 January 17 January 2013.
Your bail application was earlier rejected or it is fully passed? Allowed?
2020.
Interim bail?
interim bill.
For how many? 8 weeks.
8 weeks.
Then you surrender at right time. So have you got that custody certificate about your period of detention? Oh, have you got Acha. Custody certificate? Then it appears that the petitioner was granted interim bail for a period of 8 weeks. As per the order dated 31/2023, the Land Council for the state shall obtain a report from the concerned IIC about the conduct of the petitioner while on interim bail. There's this matter on session.
Item 6.
We think as you already know.
It will also granted the petitioner in interim bail of 3 months now. The petitioner surrendered in time. And this honorable court has pleased to the last petition for the last order. Honorable.
Surrendered.
The petitioner has filed an application for bail Miller. There is no CORAM Miller to the
What is the IA number?
IA number 147 of 2025. It is 147.
You have received the copy of that?
I have sought the copy. That I am serving a list of copies.
The Land and Council for the state has produced the written instruction received from IAC Lohunipala Police Station regarding the conduct of the petitioner while on interim bail. The said report is taken on record. Stop. It is submitted by the Land and Council for the appellant that another interim application has been filed. Interim application for bail has been filed by the petitioner, which has been numbered as IA number 147 of 2025. State Council submit that he has not received the copy of the said interim application. Let the interim application be placed on record and a copy of the interim application be served on the Land Council for the state. Put up this matter next week. Yes. Mishra.
Item 7.
গোটা সপ্তাহ করে 21 তারিখ
Item 9.
21/7/2025. Yes.
Under IA number 790/2022, pending for bail mail. And the petitioner is arrested.
No, custody certificate and criminal antecedent was sought.
That has been read in 19/6/2025, petitioner ordered to forward.
That's right. Dion. Deposition copy ଆପଣ ଦେଇ ଦେଇଥିଲେ।
That process this thing.
କେତେ ବର୍ଷ ହଉଛି ଧରିଥିଲେ?
12 ବର୍ଷ ସମ।
12 ବର୍ଷ।
13 years. He is arrested on 6/9/2012.
Total days ହଉଛି 4671. ଆଗରୁ ବେଲ୍ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହେଇଛି ନା ନାହିଁ?
CRL ରେ ହେଇନି, but ଟ୍ରାଏଲ ବେଳେ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି।
How many persons faced trial? 2.
My lord, 2 persons faced
What
trial.
happened? What happened?
And both are convicted, my lord. As per the case 48, the convict Bahadur Burandi and Narayana Burandi each are sentenced to undergo reparation upon life and to pay fine of rupees 5,000. Only each and in default.
What happened to the other
appeal?
My lord, that is CRL number. That has been filed, that is CRL number 169/2021. He has already bail matched.
What is that? Set of hard code?
CRL number 169.
Just.
That's not the.
CRL 169/2021. On perusal of the order dated 4/5/2022. That is the bail order passed.
No.
On perusal of the deposition of PWs 2, 3 and 6. And the judgment, it is found that the fatal assault was mounted by Quashing Bahadur with an axe. So far as the present appellant is concerned, he is alleged to have assaulted the deceased with a lathi. And medical officer who conducted the autopsy deceased fatal injuries have been caused by axe blows. So
You have given the axe blow.
you are.
My lord, that is the case, my lord. And the PW9 witness has been examined in court below, my lord. I want to, as per the prosecution, PW2, PW3 and PW6 are the eyewitnesses. And PW4 and PW5, both are the seizure witness of postmortem and lead evidence of the weapon that has been drawn by this matter. Therefore, I want to draw the of the PW9, who is the investigative officer. I want to place that, and PW.
No, not necessary. We are not hearing the criminal appeal. We are putting you a simple question that 2 persons faced trial, both of them were found guilty. You have preferred separate appeal. The co-accused who was facing trial, he has been granted bail on the ground that you are the main culprit in the sense you are holding a tangia and you dealt with the fatal blow on the deceased, whereas he was holding a lathi, and the postmortem report indicates that the sharp cutting weapon. Who is the doctor?
Doctor PW7. There are 9 injuries.
The
And
doctor,
even if one
you see,
injury will be the cause of the fatal death.
the doctor has noticed that there are as many as 9 injuries, out of which 8 are incised on.
Right.
So obviously this injuries has not been caused by the person who was holding the lathi. The lathi injury is that first injury, lacerated wound 2 cm into 1 cm, right? Over the right parietal region. But all the injuries are incised wounds, and that has been caused on forearm, left knee, ankle joint, right medial malleolus, then right knee, elbow joint, and right knee fracture. What is the cause of death? Was due to so multiple injuries and multiple fractures of the bones. That is the
That is the cause of death that they are stated, my lord. But if your lordship may kindly glance to the cross-examination of the PW4 and PW9, the investigating officer, the so-called eyewitness are doubtful, my lord.
No, that we cannot hear. In this bail application, we cannot adjudicate whether the evidence of a particular witness is to be accepted or not. If we give a finding here, then it would be very difficult for to arrive at a different conclusion while adjudicating the appeal finally. That's why it is always said that don't adjudicate on the acceptability or otherwise of a witness while adjudicating a bail application. It's all right in final stage.
My lord, he is in custody in 13 years, and my humble submission that since the IO and the PW4 and other witnesses say that the distance between the spot
Any
and
criminal antecedent against this man?
Appreciation of evidence.
59 years.
What is your age?
So the age is just around
46 years when you preferred the appeal. So 2021 you preferred, now it may be 50. You see, Mr. State Counsel, we have specifically directed as for order dated 19/6/25 that you produce the custody certificate and criminal antecedent. Again, same thing, you are producing one document and not producing the other one. What is the problem? Are you intending to delay the disposal of a bail application by this process? Then we will ask the Advocate General to say why this thing is done. In all the cases, one date you are producing this document, then 2 weeks we are granting to other document. So what is this? This is a question of somebody's liberty. Whether he will be getting bail or not, that's a different matter. But
for the accident is concerned that the district jail Volangir has given
order टा ଆମେ open court ରେ ଡାକୁଛୁ ନା ନାହିଁ ବଡ ପାର୍ଟିରେ ଡାକୁଛୁ ଅପଲୋଡ ହଉଛି ସେଇଦିନ ସନ୍ଧ୍ୟା ବେଳକୁ ଏମିତି କେମିତି ହଉଛି ଆପଣ ଗୋଟେ ଆଣୁଛନ୍ତି ଗୋଟେ ଆଣୁନାହାନ୍ତି
ଆଣ୍ଟିଜେଣ୍ଟ ଟା ଦେଇଛି ସେଟା କିନ୍ତୁ ବଲାଙ୍ଗୀର ଡିଷ୍ଟ୍ରିକ୍ଟ ଜେଲ ଦଉଛନ୍ତି ସେ ଯୋଉ ଇଏ ଦେରେ ଅଫର କରିଥାଏ custody certificate offer କରିଥାଏ in addition to that I am the informed that no record is available office
ହଁ ତାମାନେ ସେଠି ଥିଲେ ତ ଆସିଥାନ୍ତା ନା ଯଦି ଆଉ କିଛି କେସ୍ ଥାନ୍ତା ଆପଣଙ୍କର ସେ କେସ୍ ର ଯଦି ତାକୁ ରିମାଣ୍ଡରେ ନବାକୁ ପ୍ରେୟାର ହେଇଥାନ୍ତା ତାହେଲେ ଲାଗିଥାନ୍ତା ତା ଦେହରେ ଆପଣଙ୍କର ଯୋଉ ଆକ୍ୟୁଜ ଯେତେବେଳେ ଆସେ ତା ଦେହରେ ମନେକର ଗୋଟେ କେସ୍ ରେ ଆକ୍ୟୁଜ ଆରେଷ୍ଟ ହେଇ ଆସିଲା ସେଟା ଏଣ୍ଟ୍ରି ହବ ତାର କେସ୍ ନମ୍ବର ଏଣ୍ଟ୍ରି ହବ ତାପରେ ସପୋଜ ତାକୁ ରିମାଣ୍ଡରେ ନିଆଗଲା ଅନ୍ୟ କେସ୍ ରେ. So once that intimation is given to the court and prayer is allowed, then that is also to be intimated to the jail authority, so that say jail register re देखा जीवो जे 4टा केस की 5टा केस रे से custody रे अछि हला ताले even if he is released on bail in one case, he will not be out of jail unless he is released in all other cases. So that is the thing why this procedure is adopted. So from the jail record, it appears that only one case is there. So what is the question of other cases? Counsel for the petitioner, learned counsel for the state, learned counsel for the state has produced the custody certificate, which shows that the এটা হরিছিলে কি 365 দিন রে কেতে আসছি
13 ବର୍ଷ
13 ବର୍ଷ ହେଇଯାଉଛି ତ 4 6 7 1
12 years some
12 ठीक से କୁହନ୍ତୁ whether he has completed 13 years or 12 years. You divide it by 365.
12 ବର୍ଷ 7 ମାସ.
Or then they're more than 12 years. So, na? The custody certificate is taken on record. The learned counsel for the petitioner submitted that the petitioner, along with the co-accused Noro alias Narayana Gurandi, faced trial being charged under section 302 by 34 of the Indian Penal Code, and the learned trial court found them guilty under the offense charged, and the co-accused Noro alias Narayana Gurandi preferred a separate criminal appeal, that is CRLA number 169 of 2021, and he was directed to be released on bail while order dated 4/5/2022. And since the implication against the petitioner is almost identical, the petitioner is and there is no chance of early hearing, the bail application of the petitioner may be favorably considered. Stop. Learned counsel for the state, on the other hand, placed the bail order passed in respect of the co-accused Noro alias Narayana Gurhandi, wherein taking into account the deposition of 3 eyewitnesses, that is PWs 2, 3, 6, it was held that the petitioner assaulted the deceased by means of an axe, whereas the said accused assaulted the deceased by a lathi. And the postmortem report indicates that all the fatal injuries have been caused by axe blow. He argued that the petitioner doesn't stand in the similar footing like the co-accused, and therefore he should not be granted bail. After going through the evidence of the 3 eyewitnesses, so also we find that the petitioner was armed with a tangia and assaulted the deceased, and the postmortem report indicates that Ketanawar Sakhi, which has been proved through doctor bracket PW7, that out of 9 injuries sustained by the deceased, 8 injuries were caused, 8 injuries were incised wounds. And stop. In view of the evidence of the eyewitnesses also, the post-mortem report finding, we are of the view that the petitioner stands in a different footing than the co-accused with whom he faced trial and who has been released on bail in the connected criminal appeal. Therefore, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, as well as the ratio laid down in the case of Letty versus Counsel, we are inclined to release him on interim bail for a period of 3 months, but in normal order for the surrender certificate produced in front of, yeah. So there is another application for stay of realization of fine that is to be allowed.
Item 10.
Mail. Transport this mail. I on a regular bill 1318 of 2025. Limited surrender certificate, but you can't get it. Interim bill.
How many appellants are there?
Only one appellant, so two persons were facing trial, one was died during a course of trial. Only basic ones circumstantial.
Just a minute. One accused faced trial.
Faced trial.
And he was found guilty under 302.
Two accused facing trial, one was died during trial, and the petition.
Ultimately, the judgment was in respect of one accused, right? So 302, 201, 34, he faced trial. And he was found guilty under both the charges.
Both the charges.
Okay. When last time your bail application was rejected and you were granted interim bail?
Rejected on IN number 2728 of
an order dated one.
Order dated 16/1/2024.
16/1.
16/1.
That is the rejection order. So bail rejected.
Bail made on 28/2/2024.
Just a minute. Bail rejected on 16/1/2024. When you were granted interim bail?
25/4/2024. Last day.
Just a minute.
Right.
So for what period you were granted interim bail?
1 month, 24 days.
Achha.
Before that was granted in different IA on 29.
So interim bail you have been granted on some occasion.
Madam.
And last time we granted you interim bail on the ground of the ailment of your wife. That was for 4 weeks. On 28/2/2025.
And 26/7/2024.
You are supposed to produce the surrender certificate.
Yes, IA number 1318 and next one the surrender certificate. 1318 of 2025.
1318 तो पीछे नहीं 1317 हो the interim bail. अच्छा 1318 है. So this application you are not now facing. Okay. So two things we want to know that what is your period of detention and what is your conduct during the interim bail period granted by this court. So have you got the custody certificate?
Yes, ma'am.
Because 2 years. 2 years jama.
2 वर्ष 5 मास.
Giving fact lies on bail.
Yes, wait.
So 2 years and your bail application has been rejected on merit. What do you say? Now, what is the ground for granting you again another interim bail? On that day, it's all right, you are granted an interim bail on your wife's ailment. Now, when your bail application has been rejected on merit, and that too year in 2024, and you are in custody only for 2 years. So let it lie over and then move up. The mother of the Learning Counsel for the petitioner produce the custody certificate. It will achieve IN number 1318 of 2025, which is taken on record. It appears that the bail application of the petitioner was rejected on merit by the order dated 16/1/2024. However, he was granted interim bail for some time in different interim applications for bail. Put up this matter on such and such day, August 29. The Learning Counsel for the state shall obtain instruction regarding the conduct of the petitioner while on interim bail. Allah.
Item 11.
Where the signal petition is there.
Engagement of Mr. Deepak Ranjan Mishra. You have filed wakalat now.
SK Patnaik to Ismat is not my answer.
Just a minute. SK Patnaik?
SK Patnaik to Ismat.
Ismat. Ilmankar na katiyo. All right. Here is the prisoner's petition in which request has been made to engage Mr. Deepak Ranjan Mishra in place of Mr. SK Patnaik. Mr. Mishra has already filed Dhinama, which is accepted. The names of Mr. Swarup Kumar Patnaik and his associates shall not be reflected in the cause distance book.
Another serial 484/23 there, madam. There is also in prisoner petition that is in present in noting. Serial 484/23.
I see the prisoner's petition. Can I
find there?
No.
In the other matter, huh?
Madam.
In the other matter.
For reference में हाँ देना दबाव चाहूँगी अच्छा दीपों में नियुक्ति करें काम जामुन वकालत ना दी चंद टेम ऑर्डर पास कर दे और आर्ट सेपरेट लिख ले TRL नंबर 484 of 23 है ना तादिर भी जो अर्लियर एनगेज काउंसिल करना रिफ्लेक्ट करा जीवन बिल कर दे तादिर फिलहाल मिस्टर SK जफरुल्ला और जे यमी कमीला तेमन करना है ना
Yeah, for bail, the deposition copies are not with me. Provide.
I तापर लिखूँ ये जो प्रथम डर लिखूँ IN number 241 of 2025 is an application for bail. The Learning Counsel for the appellant submits that 7 appellants submit that is not having the deposition copies of the witnesses, and since the trial court record has been received, soft copy of the trial court record has been received, he may be provided with the deposition copies in his pen drive. Apan pair achi?
No.
So you get it in your pen drive. Similar submission is made by the Learning Counsel for the state. Let the registry supply the copies of the deposition of the witnesses examined in the trial court, learning trial, to the learning counsel for both the parties. Put up this matter. Favor of you.
1 week after.
1 week after 21st of July 2025. Yes.
Item 12.
She was free to grant 3 months interim period on the ground of there is no chance of early hearing. Director both the petitioners surrendering time, that is flat.
1 minute. 1 minute is what.
No. କେତେ ବର୍ଷ ରହିଛନ୍ତି?
10 years, as on that 10 years, 4 months, 24 days.
ଆଗ ଅର୍ଡରଟାରେ ବେଲ୍ ଅର୍ଡରରେ ଲେଖା ହେଇଛି କିଛି?
Yes,
Oh,
sir.
9 years, more than 9.
Order dated 21/5/2024. 9 years.
21/5/2024 ରେ ଆପଣ ଥିଲେ 9 years,
Aye.
ବର୍ତ୍ତମାନ more than 10 years ହେଇଗଲାଣି।
10 years, 4 months.
Are the learning counsel for the petitioner and counsel for the state? The learning counsel for the state has produced the report received from IIC Vedant police station, which shows that during the interim bail period, no adverse behavior was reported against the appellants. The report is taken on record. The learning counsel for the petitioner submitted that the petitioners are in judicial custody for more than 10 years. And since there is no chance of early hearing of the criminal appeal and paper book has not been prepared, and the petitioner has not flouted any terms and conditions of the interim bail order, in view of the ratio laid down in the case of Letty versus Swanshaw, he may be directed to be released on bail. Learned counsel for the state opposed the prayer for bail. Considering the submission made by the learned counsel for the respective parties, period of detention of the petitioner in judicial custody for more than 10 years. Since no adverse report has come against the petitioner relating to his conduct while on interim bail and absence of any chance of early hearing, we are inclined to release the petitioners on bail allowed.
Item 13.
Yes, Mr. Chan.
14 years, 6 months in custody. 14 years, 6 months.
ଥିଲା କି ଆପଣ ନାଁରେ କିଛି
He before the ballot appeal in it, after much delay. So 7-8 years.
No, जो comprehensive affidavit अपन
8 years, 8 antecedent is there.
That's
Sir, we have filed.
bail ଆଗରୁ merit reject ହେଇଥିଲା?
No, for the past 7 days before now. I filed one interim application that was.
କି ପ୍ରକାର କେସରେ ଆପଣ 8ଟା କେସ୍ କଣ ଥିଲା ଆପଣ ନାଁରେ?
I filed the affidavit.
Fine. Zero affidavit. In 379 ଗୋଟେ.
ପୁରା 14 ବର୍ଷ ତଳେ ଯାହା
323,506.
307 arms structure.
394 acquitted ହେଇଛନ୍ତି. 394 ଦିଟା କେସରେ acquitted ହେଇଛନ୍ତି ଅଛି। ଆଉ ଗୋଟେ ଅଛି ତାପରେ ବି acquitted ହେଇଛନ୍ତି।
110.
Conduct and dispose of the. The pending case how kon achi thaber?
Yeah, sir.
Acquitted na.
14 years, sorry. All cases are up here. About 15 to 16, 18 years back.
2009 केस अब ये जो घटना टा केबे गला
एटा होची आपन 2011
से सेतेबेले चलथिला ना माने 7 8 9 10 पर्यंत थिला 11 पर्यंत आसिला माने प्रथम छोटो छोटो करी 379 नु 394 394 पुनी प्रमोशन 307 307 को 302 गला तापरे रही गले पुनी गले आउट टाठू बड़ ऑफेंस कोन हो
now
Committed almost all the offences of IPC. Varieties of offense.
कोन पूछंदी
and
ये सब गुडा केस एक्यूटल है यही छी
co-convicted has been acquitted also. There is no allegation against him directly that he was facilitating the crime. That's why Malgas cannot grant him.
केते वर्ष हेलाणी आपण
ये 14 वर्ष 6 मास.
नहीं नहीं माने बयस
he was 31 years by then.
31 years
By then,
31 years अपन इलेक्शन दी पूरा क्रिमिनल अपील ले आ कोन 2 वर्ष रे आपण 42 43 कुन की
he was 25 years on the day of conviction was in 2011.
आपण
14 वर्ष
अपील में
31
इलेक्शन बर्तन 42 किन दियो
32. You have potential left to commit further crime.
रंडोड़ को
ऑफिस एंड पर period time with
कोन ऑफेंस कोन 302 कोन करछंदी
allegation was when a obscure session was going on, it is alleged that the petitioner appellant along with the other co-convict, they went there and the petitioner fired one shot.
Gunshot injury.
Yes, one shot. One shot.
1 and 3 the eyewitness also.
से पुनी बंदूक मारछंदी और से कोन
It was 13 is the
Okay, one shot.
In the cremation ground.
नहीं obscure session मतलब भोजी गंगा भोजी
tactic in the
so any kind of situation with the possibility if you was since it caused by firearm to take instruction and he had got 8 criminal antecedent. Of course, report is there, he has been acquitted. That is his comprehensive report. So if this sort of person is released on bail, whether there is any problem would be just ascertained from the locality.
And the informant family.
Get it.
Deceased family, whether any threat is there.
Regular appearance with the police.
एमान तो acquitted है ये ना.
नहीं अपन the eyewitnesses have supported. That is how he has been found guilty.
Only eyewitness double 10 with the 1 and 3 they are against the traffic.
Yes, they supported the case.
No, even though you are making a submission that in such type of cases the witnesses would turn hostile, but it is not a fact here. Even though it's a case of firearm injury, the witnesses deposed against him and he was found guilty. So we are now
Witness protection, report fishing. The witnesses don't have support of the case. That's how it may be.
You are not actually applying it properly. That is how major cases the witnesses are turning hostile. That has been laid down in detail what is to be done with the witnesses.
One more thing, suppose we will release him on bail and the witnesses, those who supported the prosecution, their life may be under threat.
That is exactly.
So all these things you have to ascertain and tell us so that we can grant bail.
So merely formulating the scheme and without providing the infrastructure and practical reality that to see that it is carried out. କିଛି କରିବେନି ସେ ୱିଟନେସ୍ ତ କାଲି ସକାଳେ ତାର ଲାଇଫ ରିସ୍କ ହବ ସେ କଣ କହିବ ଘଟଣା ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଥିଲେ ବି ବଦଳି ଦଉଛୁ।
You file a comprehensive report regarding this. Whether any.
The London Council for the State, comprehensive affidavit has been filed by the London Council for the petitioner, showing that in all the cases, the petitioner has been acquitted. Copy of the comprehensive affidavit has been received by the London Council for the State. You have obtained instruction that this affidavit is correct.
We have to take instruction because they are like.
କହୁନାହାନ୍ତି ଆମେ କହିଲା ପରେ କହୁଛନ୍ତି ଆପଣ ପାଇଲେ ଆଫିଡେଭିଟ୍ ଟା କେବେଠୁ ପାଇଲେଣି ଆଉ ଏଇଟା ସତ ଲେଖିଛି କି ସବୁ କେସରେ ଆକ୍ୟୁଟାଲିଟା ମିଛ ଲେଖିଛି ସେଟା ନେବେନି ଇନଷ୍ଟ୍ରକ୍ସନ The London Council for the State submits that he is yet to receive instruction regarding this affidavit and also further instruction that whether the release of the petitioner would have any adverse effect on the law and order situation. To that effect also a report be produced out of this matter, the 21st of July 2025. Yes.
Item 14.
Madam, कौन ला कौन तुम?
Madam, clear for bail, an application. And clear for bail under section, Act for 302-307 of 34 of IPC. Madam, last occasion, instruction to take the accused health condition.
Petitioner number 1 is suffering from paralysis. So you said that petitioner number 1, Dhruva Guru, was suffering from paralysis. That was your contention. We asked for a report on that.
Dhruva Guru, Giri Govardhan.
Dhruva Guru?
Dhruva Guru, one two applicant hochi Giri Govardhan Guru. Two applicants.
No, it's all right. But in that order, last order, we have mentioned about the.
Dhruva Guru.
Yes, right.
Applicant number 1.
Stable.
कौन आसी तो paralysis कौन को था? Dhruva Guru, so and so, not involved. तो ये था.
Understood. Health condition of the above person.
Dhruva Guru, yes, he is a known case of so and so disease. He has been sent to himself so and so for polyneuropathy in different time. Accordingly, he had received treatment. He has been sent to so and so. This administration, health condition of the above person number 1 appears to be stable. And
you are getting good treatment.
ଆପଣଙ୍କୁ ପୋଲିସ ନେଇକି ଯାଉଛି ଗାଡିରେ ନେଇକି ଯାଉଛି ଆପଣଙ୍କୁ ସବୁ ସେ ଡିଷ୍ଟ୍ରିକ୍ଟ ର ପ୍ରିମିୟର ହସ୍ପିଟାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ହସ୍ପିଟାଲ ରେ ଚିକିତ୍ସା କରାଉଛି ଆଉ କଣ ଅସୁବିଧା
Costed period more than 11 years. No eye weakness.
Madam, if you come out, whether you can have this kind of treatment, can you afford to do that?
ବାହାରକୁ ଆସିବେ ଆପଣ ପୋଲିସ ନେଇକି ଯିବେ ଟ୍ରିଟମେଣ୍ଟ କରିବା ପାଇଁ ଆପଣ ନମ୍ବର ଯାଇ ରାତି ଅଧରୁ ଛିଡା ହେଇଥିବେ ଏଇ ସବୁ ଜିନିଷ ଆପଣ ପାରାଲିସିସ୍ ହେଇଛି ବର୍ତ୍ତମାନ ତ ଯାଉଛନ୍ତି ଭଲ ଟ୍ରିଟମେଣ୍ଟ ପାଉଛନ୍ତି ସବୁ କିଛି ଅଛି ପୁଣି କାହିଁ ଯିବେ ବାହାରକୁ
Interim period 7/10/2014 21/2025 3 months right away ଆସିଛି
ନା ସେଟା କି ମନା କରୁନି ଯାଇଥିଲେ ଆପଣ 7/10/24 ରେ
ଆପଣ କଣ୍ଟିନ୍ୟୁଅସ୍ ଟ୍ରିଟମେଣ୍ଟ ଚାଲିଛି ବାହାରକୁ ଆସିଲେ ଆପଣ ଟ୍ରିଟମେଣ୍ଟ ପାଇବେନି at government cost you are being treated in very good hospitals. Why are you taking that risk of coming out?
Bail application has been rejected on merit.
No, man.
Treatment is going on.
Aladdin Das. And
ସବୁ ମ୍ୟାଡାମ ସେଗୁଡା ସବୁ କନସିଡର ହେଲା ପରେ ଆପଣଙ୍କୁ interim bail ଦିଆହେଇଛି ହେଲା. If you would have considered all those aspects and you would have been granted bail till disposal of the appeal, but we are not inclined in view of the evidence of the eyewitness and medical evidence. ତେଣୁ ବର୍ତ୍ତମାନ ଆପଣଙ୍କୁ 3 ମାସ ଦିଆହେଲା.
the district PW1, para 8 and judgment page
ଆପଣ
7.
କଣ ବୁଝିପାରୁନାହାନ୍ତି? ଆମେ ଓଡିଆରେ କହୁଛୁ ଆପଣଙ୍କୁ, ମେରିଟ ରେ ଆପଣଙ୍କ କେସ୍ ଟା ଗ୍ରହଣୀୟ ନ ହେଇକି ଆପଣଙ୍କୁ 3 ମାସ ଇଣ୍ଟରିମ୍ ବେଲ୍ ରେ ଦିଆହେଇଛି 7/10/2024 ରେ. ପୁଣି କେମିତି ଆମେ ମେରିଟ ରେ କନସିଡର କରିବୁ? ବର୍ତ୍ତମାନ ସେଇଟା ହଉଛି କଥା. ହଁ, ତ ବାକି ଚିକିତ୍ସା ଆପଣଙ୍କର ଚାଲୁ ରହିଛି.
Wait for some time. And let us see.
We are not rejecting but deferring it for consideration. It remains some time.
Madam, my lord, regular bail ଗଲେ ତା ଘରେ ଟ୍ରିଟମେଣ୍ଟ ହବ.
ଘରେ ପଇସା ଖର୍ଚ୍ଚ କରିବେ ଆପଣ. ଅଛି ଭଲ ପଇସା ଅଛି ବୋଧେ ଯାହା ଜଣା
ଆଜ୍ଞା, ସେ ଟିଚର ଥିଲେ ଗିରି ଗୋବର୍ଦ୍ଧନ ଯେ ଆଶ୍ରମ ସ୍କୁଲ ଟିଚର ଆଉ ଏ ଗୋବର୍ଦ୍ଧନପୁର ଯେ ବିଜନେସ.
The Learning Council for the state has produced the written instruction received from the IAC Sassoon police station to show that the petitioners have not involved them in any other case during the period of interim bail. The report is taken on record. The report has been produced from Senior Superintendent Circle Jail Sambalpur, wherein it indicates that so far as the appellant number 1, Ruboguru, is concerned, in view of his ailment, he is regularly taken to the Bimsar Burla, also district headquarters hospital, and treated there. The reports are taken on record. The matter will be placed in the second week of August 2025 for consideration of the bail application. Here.
Item 15.
Okay.
This case, appellant has been convicted in 302.
When prisoner petition has come for Circle Jail for engagement, first it was there for engagement of Mr. Sam Manohar. Then another prisoner's petition has come for. So
Wrongly, they have confirmed that.
the latest one is
Acha,
okay. You have filed your VNAM also.
earlier I have filed.
Earlier that was there.
No, 25 ରୁ batch start.
No, ଏବେ 2025 ମସିହା. So your bail application was earlier rejected or it?
6/12/2023. 6/12/2023.
6/12.
Question for page
Custody period?
Custody period 9 years, 2 months.
Have you got the custody certificate
No,
with you?
Custody certificate, no.
To get the deposition copies here, take from you in your pen drive, receive it. The IN number so and so, there is an application for bail. The Learning Council for the appellant submits that the petitioner is in judicial custody for more than 9 years.
Yes, sir.
9 years. Let the Learning Council for the state produce the custody certificate. Stop. Land Counsel for the state further submits that he is not having the deposition copies, and since the soft copy of the trial court record has been received, he may be given the deposition copies in his pen drive. Let the registry supply the deposition copies of the witnesses in the pen drive of the Land State Council. Put of this matter in the week commencing from 21st of July 2025. The Land Council for the state shall produce the custody certificate in the meantime. Achata, I would like you know the petition. One petition was received from jail regarding engagement of Mr. Shyam Manohar in place of Mr. A. Bhuiya, which is at flag A. And another petition was received regarding engagement of Mr. Akash Bhuiya in place of Shyam Manohar, which is at flag F. Since the petition at flag F, which is dated 6/5/2025, is the latest one, we accept such prisoner's petition, and the name of Mr. Shyam Manohar shall not be reflected in the cause list henceforth. Mr. Bhuiya has already filed Wakalatnama for the appellant. Yes, next.
Item 16.
Please,
Item 17.
Some of the active persons were on interim. Must say, my lord has directed the council to take inspection whether during interim period they have committed any offence.
Okay. The Land and Council for the state submits that is yet to receive instruction regarding the conduct of the appellants in this appeal, in the appeals during the period of interim bail. Put up this matter, gote saptah pare rଖିଦିଅନ୍ତୁ gote kare order ta pass karibe eja first are bail le thila tale seithare kardebe ebong please this matter along with us.
Item 18.
Paper book?
I've already been prepared.
What do you want?
It is for hearing and opinion.
Bail application has been rejected.
Not today.
So, how many years you are in custody?
Since
What is the date of occurrence?
2019.
2019.
1/6/2019.
302 case.
Well,
Eyewitnesses are there.
yes.
Who is the eyewitness?
Figure 10. The eyewitness for some discrepancy is there.
Just a minute. PW10 hochi eyewitness.
No, P10, 1 and 2 also eyewitness. Informant also eyewitness.
मतलब ठीक से कौन कितने जन eyewitness?
4 eyewitness.
किए के कौन आती?
1, 2, 4 and 10.
PW1, 2, 4 and 10.
10.
Who is the doctor?
19. You're 19.
PW19. So, chopund,
Well,
खाली बड़ा बड़ा सब chopund जाइए. बहुत रे marching दिया कौन?
Kati.
Kati. चारटा पांचटा chopund रही थी. बड़ा सब vital part of the body. Neck, so on so, अच्छा. What fracture of the ribs?
Mr. Bharat, prosecution is not a concern. Nobody has disclosed what is the motive behind the crime.
Not have eyewitness re motive.
There is the eyewitness.
Direct evidence.
There is must be a motive.
Mr. When the case is based on circumstantial
Motive is play vital role.
Otherwise-
But here in this case, there is some motive to assault the case with prosecution while the deceased sitting near a mondop, village mondop.
Motive is known to the author of the crime. That is in the mind, and it is very difficult for the witnesses to say why. They may guess in something. Unless they are aware, you may not know. You cannot enter into the mind of a person why is acting in a particular way. Very difficult.
It will also,
You will also die in detail for this.
Dying declaration अछि. Kit number sec?
We don't 12.
Putre marla si?
Kati
Katire. So you are in custody for, as you said, 7 years.
6 years.
6 years.
The 3 years, 9 months, are the 5 years something.
କାହିଁ ଇଏ କରିବେ କାରଣ ହିୟରିଂ ଏତେ ଲାଟେଷ୍ଟ ମ୍ୟାଟର ଗୁଡାକ ଆଡ୍ କରିହବନି ବହୁତ ପୁରୁଣା ମ୍ୟାଟର ରହିଛି ସେମ୍ ଥାଉ ଏଟା ଲେଖନ୍ତୁ କେସ୍ ଇଜ ଆର୍ଜେଣ୍ଟ ପର୍ଯ୍ୟନ୍ତ ଅଗଷ୍ଟ ଶେଷ ଆଡକୁ ୟେସ୍ ନେକ୍ସଟ
Item 19.
Appellant number 2, all other appellants have been
Mr. Lalitandu, we have filed one on behalf of appellant number 2. Chittaranjan Saw associate tried 1 and 2 without the consent of so and so. ସମସ୍ତ ନାଁ ଆସିଛି ତ ଏଥିରେ ତ କେତେ ଜଣ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି?
7 appellants, 6 appellants have been released on bail by this court.
No, ଯୋଉମାନେ ନୂଆ ଓକାଲତନାମା ଫାଇଲ କରିଛନ୍ତି ସେମାନଙ୍କର ନାଁ ପଦ ଲିଷ୍ଟରେ ଅଛି ତ? ଚିତ୍ତରଞ୍ଜନ ସାହୁ it is there, then Lalitandu Bhuiya, that is also there. Yes. We have filed an application for bail for appellant number 2 only. Agur reject ହେଇଛି?
Before 1 year it will be.
Before 1 year.
କେବେ ମାନେ date ଟା କେବେ?
21/8/20.
21/8/24.
Chima Munda.
तो 1/3/7 एमाने बेल रिलीज हेले नंबर 2 रो बेल रिजेक्ट करागला कौन पे रिजेक्ट करागला किसी कारण नहीं पे लेकिन
The allegation that he has cut off the power.
हाँ
ये line टेबल काटी करा. All other persons have asserted, but the present petitioner has cut off the power supply.
He has not asserted.
He has not asserted that.
No,
There is no allegation.
who is the eyewitnesses only?
Yes, PW4.
PW4.
Cross examination for the accused persons except accused chairman. Accused chairman.
Wrong. I know all the accused persons once occurrence took place. Accused persons came together and assaulted. समस्त को तो कहते
Yes, sir.
तापरे कोडी बाहर कले
Paragraph 3.
Cut off the power supply.
Cut off the power supply to the
कोडी
Para 3 top.
अच्छा para 3 and thereafter all the accused persons are assaulted. How do you say, Mr. जो माने मारी चंती से माने बेल ले पड़े ले ये उड़े पावर सप्लाई डाउ कट ऑफ कर दला से ता बेल टा रिजेक्ट हला. How many years you are in custody?
6 years. In 7 it will be 6 years.
You see, somebody धरो पावर सप्लाई कट ऑफ कर दला ताले तार इंटेंशन हुए तो थाई पाए जे एमती पावर कर की कोटे पळेइबो पावर सप्लाई कर देला माने कोन इमान असॉल्ट करियो बेली धरा जियो की अंधारे के काउ देख परिबेनी दैट मे आल्सो facilitate the deceased to escape from that place can only be the reasonable conclusion would be that that would facilitate the accused persons to assault the deceased.
That the group of the person, the accused person.
ठीक अछि समस्ते आसिले जणे जाईगी नि पावर सप्लाई कट ऑफ करला जो माने मारिले से मान को बेल हे जाई छी ये पावर कट ऑफ कर दला बेली ताकू बेल ता कोन पे रिजेक्ट
Also, I have seen the accused person assaulting the deceased.
assaulting माने accused persons माने
Other accused persons.
other accused persons.
There are
Because-
7 accused persons.
हाँ तापरे पैराग्राफ 3 रे मध्ये कहूची आई सॉ दी accused चारि लाइन लास्ट चारि लाइन PW4 I saw the accused Chima cutting to the house of the deceased from the transformer situated near his house. तामाने हाँ the transformer पाकरी काटला. I cannot say the exact distance. And maybe that
he might not have participated.
He had not come to the actually to the scene of occurrence. Or the learning counsel for the petitioner and counsel for the state. The learning counsel for the petitioner submit that the petitioner this application for bail has been filed by the this is IN number कितने number right IN number 277 though 277 of 24. This is filed by the appellant number 2 Chima Munda submit that the petitioner is in judicial custody for 6 years.
On 15/7 it will be 6 years.
15/7
15/7.
or about 6 years from now. The petitioner and others who are the appellants in this criminal appeal memo gang or jail criminal appeal actually, file the bail application, and though all other appellants were granted bail, the bail application of the petitioner was rejected by order dated 21/8/2024. The Learned Counsel for the petitioner submits that PW4 is an eyewitness to the evidence. PW4 is an eyewitness. PW4 का नाम लग गया तो बुद्धूराम मुंडा is an eyewitness to the occurrence, and though in the examination in chief he has stated that all the accused persons came together to his house and assaulted the deceased. This is now the Dinabandhu though?
Yes, sir.
This is Dinabandhu with Thenga. But in the cross-examination, he has specifically stated that the petitioner cut off the power supply to the house, and thereafter all the accused persons assaulted the deceased. And further stated that the petitioner cut the power supply to the house of the deceased from the transformer situated near the house of the deceased. However, he could not say the exact distance. It is argued that since the accused persons who actually assaulted the deceased have been enlarged on bail in view of the specific role attributed against the petitioner who have cut up the power supply, his bail application may be reconsidered, particularly when there is no chance of early hearing of the criminal appeal in the near future. Stop. Learned Counsel for the state oppose the prayer for bail, considering the submission made by the Learned Counsel for the respective parties, period of detention of the petitioner in judicial custody, nature of overtake attributed against the petitioner. We are inclined to release the petitioner on bail allowed.
Item 20.
Maybe present appellant. He said custody 4 years, 2 months measure, and he was on bail during the trial measure.
What is the period of detention?
4 years, 2 months.
4 years, 2 months.
Your bail application was never rejected on merit.
But as not placed in 12/8/24.
You have received the deposition copies?
No.
So is it a case based on eyewitness account or circumstantial?
Circumstantial.
What are the circumstances?
Only circumstance that the petitioner is a husband, and it is last there the prosecution case is there.
Oh, you are the husband of the
Husband.
And where the dead body was found?
From the inside the house in the hanging position.
Okay, but what
Father
about
and
the
mother.
what about the doctor's evidence?
Doctor said
We do 19 is the doctor.
Huh?
We do 19 is the doctor.
No. Is it a case of homicidal death or
Homicidal death.
homicidal? Doctor has stated that it is a homicidal death.
Cause of death is asphyxia.
Acha, you were only staying or there were other family members?
Other family members, father and mother. They have also faced the trial, and they have been acquitted from the last minor. And 304B and 298 also they have been, it is second appellant also acquitted. Convicted as a 302. And the father of the deceased PW7 and the mother of the deceased PW4, they have initially first in their chief
They are implicated in the cross examination. They have results from their evidence.
No, it's all right. But what is your case? You are not there in the house.
I am not in their house in the DW1. It is the defense that the present appellant with his friend Miller, he went to witness the Dando Miller. At the time of appearance, he was not there. When he was returning, he saw that the door was open and it is in the hanging position.
Hanging.
You see,
Door was closed from inside.
No, open.
Question number 27 of the and 29 of the accused statement. It is formed of recording the Mishra. That how the body of the deceased was found hanging position in your house. What to say? Because taro ita hoji apanakara thyroid bone fracture heikini, so it is not suicidal death. ତାର ଗଳା ଚିପି ମରା ହେଲା ପରେ ଟଙ୍ଗା ହେଇଛି। ତେଣୁ ମୋର ଉତ୍ତର ଦେଲା ଆମର ପେଟ ଖରାପ ଥିଲା, ମେଡିକାଲ ଔଷଧ ଆଣିଲି, ସେଦିନ ଗାଁରେ ନାଚ ହଉଥିଲା, ମୁଁ ନାଚ ଦେଖି ଯାଇଥିଲି, ଆସିଲା ବେଳକୁ ଦେଖିଲି ସେ ଝୁଲିଛି। ତେଣୁ ଆଉ ଗୋଟେ ଆପଣ କହିଲେ କ୍ୱେଶ୍ଚିନ୍ ନମ୍ବର 29 ରେ ଯେ ତା ଦେହ ଖରାପ ଥିଲା, କଷ୍ଟ ନ ସହିପାରି ସୁଇସାଇଡ୍ କଲା। That is your statement, but it is not a case of suicide. So
it means he thought that it may be suicide.
no, it's not right, but if it is, you thought that it is a suicide, but you are there and
At the time of us, I was not there.
no, that you say, but then ତାକୁ ମାରିକିନି ଟଙ୍ଗେଇଲା କିଏ hospital? ମରା ହେଇଛି ନା, evidence ହଉଛି fracture of thyroid bone. So that is how the opinion has been given that it is a homicidal death. The doctor is PW19.
PW19.
On dissection, internal feature of Uchi. On dissection, there was fracture of hyoid bone, larynx, and hyoid cartilage with clotted blood beneath the ligature mark. And opinion Uchi cause of death is due to asphyxia by a constricting force around the neck, consistent with strangulation. Very clear evidence is strangulation.
Yes, sir.
No witness to that number.
We will continue IO. We will continue the IO. 2022. I visited the spot on that day at about 1:20 p.m. During spot visit, I found that dead body of the deceased Jilisha was lying on the floor of our in-laws house.
In front of the uncle of the deceased, they have untied
Irrigation material, plastic rope was found lying near the dead body.
There is no mark of violence as stated by the IO. If
Doctor says there are injuries. Doctor says.
Yes, doctor says the injury. True. But the IO says there is no mark of violence and there is no sign of struggle of the victim. If anyone has
no, nobody knows when this occurrence has taken place, and you have got sufficient time to cause disappearance of all this evidence, and you left the spot and taken a plea that I had gone to purchase medicine and he was suffering. So what medicine? Who is the doctor who prescribed? What is the disease he was suffering from? And
intoxication.
Even though you have brought medicine to her, then why she would commit the suicide? Suicide question is ruled out. Who will commit the murder? So these are all against you. ଆପଣ ଗୋଟେ ଏମିତିଆ ସ୍ୱାମୀ ଯେ ଆପଣଙ୍କ ଦେହ ଖରାପ ହେଲା ସ୍ତ୍ରୀର, ତା ପାଇଁ ଯାଇକିନି ଔଷଧ ଆଣିକିନି ଦେଲେ, ସେ ତାପରେ ତାର ହୋମିସାଇଡାଲ ଡେଥ୍ କେମିତି ହବ ଆପଣଙ୍କ ଘରେ? ଆପଣ ବୁଢା ବାପା ମା ରହୁଛନ୍ତି, ଆପଣ ରହୁଛନ୍ତି, ଆଉ ତ କେହି ନାହାନ୍ତି। So you have to explain it. You have not explained, or so that is how 106 of the Evidence Act is very material in this case. How many years after the marriage this occurrence took place?
8 years.
You have no issues out of the wedlock?
One son is there with my mother, with my parents.
Now you are in custody, you say?
4 years, 2 months. Giving trial your lordship granted
There
bail.
is some for more time, we'll see that, yes, after August litigation. Next,
Item 21.
Mr. Mishra. Not there. Next,
Item 22.
Mr. Raut. Next,
23.
20, Miss Vinny Mishra.
Mishra.
On Mishra, Land Counsel appearing for Mr. Dharanidhar Naik, Senior Advocate, 6 for an adjournment, adjournment. Yes, next.
Maybe pardon your lordship, item 22, I just received a call from Mr. Rao. Lordship, that also may be adjourned.
All right, same problem. Counsel on Mishra appearing for Vrindavan Rao, 6 for an adjournment. Yes, next.
Item 24.
Mr. Mahanti.
Holland is in custody for 9 years, 6 months. Near about 9 years, 6 months.
You have received the deposition copies?
Yes, madam.
So, custody is 9 years, 6 months.
Near about
Custody certificate I have not received.
Direct evidence.
Yes, eyewitness there, leading to discovery is also there.
PW?
8.
Who is the doctor?
PW
11. Leading to discovery PW 5.
What PW 8 has stated?
70 years old.
Who is 70 years?
PW 8.
कौन है last 70 years?
He has
It is
seen
to be
that.
disbelieved because he is a witness of 70 years ago. Huh? Morning work ଦେଖୁଛନ୍ତି କେମିତି ଚାଲୁଛନ୍ତି ସବୁ ଯୋଉମାନେ 70 years 65 years କେତେ ଜୋରରେ ଚାଲୁଛନ୍ତି କେତେ active ଅଛନ୍ତି
ଯୋଉଟା କହିଛି ସେ
ସେଇ ଏଜ୍ ସେତେବେଳେ ଗୋଟେ ଥିଲା ଅବିକା ସବୁ 70 years fit and fine ଦଉଛନ୍ତି in view of the technology medicines so what he has stated?
My lord, the accused Amara entered into our house and caught the throat of my daughter-in-law.
कौन ପାଇଁ?
The present petitioner is the husband of the granddaughter of PW8.
Petitioner is the
granddaughter of husband.
Granddaughter's husband. There was dispute between the husband and wife was residing outside, my lord. The deceased is the mother-in-law of the accused, my lord, present account. ଶାଶୁ କୁ ମାରିଥିଲେ
ମାନେ ଶାଶୁ କଣ ପାଇଁ ମାରିଲା ଯେହେତୁ ଝିଅ ଗଣ୍ଡଗୋଳ କରି ଆସି ରହିଥିଲା ଏଠି ନା କଣ
ଏଠି ରହୁନଥିଲା ଆଉ ଗୋଟେ ଜାଗାରେ ମାମୁଁ ଘରେ ରହୁଥିଲା
allegation that he has requested him to return. When he did not return, he killed his mother.
ବେକ କାଟିଦେଲେ
corresponding injury is there and leading to discovery PW5.
Leading to discovery of what? That knife?
Yes, my lord.
Produce
PW11. Incised wound present over the right side neck extending from behind the right ear till the level of the sternum. An incised wound found to left forearm. Incised wound on the right hand wrist.
Another son-in-law
ତ ଆପଣ ଆଟାକ୍ କରିବାକୁ ଚେଷ୍ଟା କରୁଛନ୍ତି ସେ ତାକୁ ପ୍ରୋଟେଷ୍ଟ କରିଛି ପ୍ରଥମେ ତେଣୁ ଲେଫ୍ଟ ଫୋର ଆର୍ମରେ ଇଞ୍ଜୁରି ଅଛି ତାପରେ ରାଇଟ୍ ଫୋର ଆର୍ମରେ ଇଞ୍ଜୁରି ଅଛି ଦେନ୍ ୟୁ କଟ୍ ଦି ନେକ୍ there is 3 attempts, as it appears, to kill. The first 2 he was saved, she saved herself. Perhaps she raised the hands one after another. Thereafter, the snake was caught. Another son-in-law in the next room, he is silent about.
He locked the door from the outside.
That was not.
No,
You see, it's not a number of witnesses. Quality of evidence is relevant, and one witness, if we find that his evidence is believable, his evidence is clear, cogent, trustworthy, that is sufficient. And how do you overcome PW8? The other person, if he has not courage to open the door, come to save the lady from your assault, and
the accused locked the door from the outside.
ସେଇ ଯୋଉ ଲୋକଟା
ସେ ଯୋଉ ଲୋକଟା ଥିଲା ସେ ଘରେ ଖୋଲା କରି ବାହାରିଛି।
PW8 କହୁଛି, ସେଟା କିନ୍ତୁ ପୋଲିସ ଆଗରେ ମନା କରୁଛି। ଛାଡ଼ନ୍ତୁ ଏଗୁଡା।
It will be at least 10 months. 10 years.
10 years.
9 years, 6 months.
How do you judge? September.
It will be 10 months. 10 years.
September. Yes, next.
Item 25.
Yes, Mr. Tripathi.
Convicted on Section 376.
ଏତେ ବେଲ୍ କେମିତି ମିଳିବ? ଶିକ୍ଷା ଗୋଟେ ଦିନ କ୍ରିମିନାଲ ଅପିଲ ବେଲ୍ ନା ଆଉ କଣ ବେଲ୍ ନା?
Convicted on Section 376 for life.
ଯାଇଥିଲା ନୋଟିସ୍ ଯାଇଥିଲା?
Yes, I am appearing
for the info.
The petitioner is the teacher. And
There is a delay in lodging the FIR 2 years. And so far as victim statement is concerned, madam, he has not stated anything about sexual. He has only stated physical relationship. The basic of the case is, my lord, that a viral was made by somebody.
No, you mean to say that the victim in her evidence has not stated anything which would attract the ingredients of the rape?
Yes.
Who is the victim?
We don't want.
Physical relationship means